whatever the changing needs and changing dimensions of human life needs a different shape of criminal laws that have been achieved by the Indian Parliament, and now the new laws were introduced for we people. What are the new changes in Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshi Adhiniyam must be known to the professionals, must be known to the students, must be known to the common man. And so, awareing all these issues or creating awareness of all these issues to the people was very necessary. And so, with the inspiration from our chairman, Veshkandi Dalit Shikshan Prasarak Mandal, Babasaheb Mahendraji Nile has guided us to organize such workshops. So, Secretary Shashikant Babasaheb also guided us, and he has inspired us. Our beloved LMC member, Advocate Jitendra Jinile, has also guided us on these issues. We have recently organized the workshop on criminal law in Bar Association Dhule also. We have understand the need of students. We want to enhance the profoundness of knowledge of all the students and professionals in this regard. So this workshop is organized for that purpose because our Dr. Babasaheb Ambedkar Memorial College of Law is established in 1975. Buddhavasi Advocate Raosaheb Ashokji Nide has established this college on the advice of Dr. Babasaheb Ambedkar. So the intention behind opening of this college is to bring the downtrodden in the mainstream of the society, to uplift every needy person, to uplift the poor and needy person is the object behind establishing this college. So with the blessings of Buddhavasi Advocate Raosaheb Nide, we are continuously trying to aware the people in legal sense. So this is one of the efforts. So today in this program, Dr. Rahul Nikam, Professor Harshada Patil, these are our college alumni only, my past students. So we'll highlight you the different topics. Again, the HOD of Dr. Babasaheb Ambedkar University, Professor Dr. Anandji Deshmukh will also highlight you the topic. So take benefit of whatever the guidance given to you in this online workshop. Wish you all the best. Thank you.
Thank you, sir. So there are almost 75 participants now. So without wasting any time, I would like to invite one of our students, Ms. Kalyani Mandore, to introduce our first resource person for today's workshop, Professor Harshada Rajput. Kalyani. Kalyani, are you there?
Yes, sir.
Okay. Over to you.
Good morning, everyone. First of all, thank you very much for giving me the opportunity to introduce our today's resource person, Professor Harshada Rajput ma'am. Professor Harshada Rajput ma'am is ex-student of our college. She has completed her LLM from Pune University in the year of 2010. She is qualified NET and now pursuing PhD in law. She also has done many short courses like information technology law, constitutionalism, law and human rights, and e-content development, etc. She has published and presented research journey and international conference on misuse of laws against men. She also successfully guided 10 students to LLM courses. Professor Harshada Rajput ma'am has achieved great success in her field and has significantly contributed to community and society. Her achievements and dedication to her work serves as an inspiration to us all. Thank you, ma'am, for your presence today. Thank you.
Thank you, Kalyani. And I must say thanks to all my Gurujan, those who have given me such an opportunity. I must say to this that if I'm in this level, you are there behind all my success and to build me. So it's a great opportunity to speak before you. Thank you so much. So as it is a time constraint, we have to talk about the law for what I'm here to speak. Bharatiya Sakshi Adhiniyam. First of all, if we are going through the history, I'm not going to say about what was there, the history into Indian Evidence Act, but I must say that the first word Bharat, it was a controversy in the parliament in the month of September 2023 with respect to the several other debate in the parliament, which is related to Bharat. According to the speakers in the speaker of the parliament, they were in a controversy to consider that if we are using the word India, it commands to the controversial to the considered to be a colonial slavery. That's why to avoid using the term India, it has to replace with Bharat. As well as if we see that it is supported even Article 1 of the Constitution, which speaks about India means Bharat. As well as if we see that the Act, Indian Evidence Act 1872, and if we are going to translate in as a Maharashtra or any other state, it is considered to be Sakshi Purava Niyam, Adhiniyam. Whereas if we consider that Purava Kaida, sorry, if we consider Bharatiya Sakshi Adhiniyam, it cannot or it not needed to be translated in any regional language. It would be as it is. Why it was needed to change into it? Because if we see that the act was there, introduced in 1872, implemented as well as enforced from that and enacted into the same year. And it was mainly few sections were there or so many sections were there, which is not compatible to today's time or for the today's generation. As well as we can say that law or it is a need of change, is a need of a society. That's why a social transformation has to be required in the law also. So if you see that the context of Indian Evidence Act, and if anyone among you has gone through the Bare Acts, the Bare Act itself contains what was the comparison between the earlier law and the new law. We are not going to see that in total comparison because you can also see, but we will focus on the particulars or principal changes which is there to today's need of a generation plus today's entire situation. Now, if you are going through the comparison of previous law and the new law, there is several things have been introduced in the new law. Like example, if you are going through that, there are the removal of several some sections and addition of a section plus schedule. The schedule was not there in the earlier law, whereas the schedule is now introduced in the new law, that is Bharatiya Sakshi Adhiniyam. So we can in short say that it is BSA 2023. Yes, it was adopted in 2023, whereas it is implemented recently on 4th July 2023. There are several other colleges or there are several other authorities are there, one who has the helping hand to draft the law, which is the criminal law, and they have given lots of support to the government that what changes are required to be made into the law. The new Bharatiya Sakshi Adhiniyam. If we are going through it, we can consider that to consolidate several other things into one. That's why there has been an introduction and previous law has been replaced into new, as Indian Evidence Act has been replaced into Bharatiya Sakshi Adhiniyam 2023. If we see that the first thing is what was removed, we'll start with that. What was removed from the previous law? If you are going through section 3, para 10 of Indian Evidence Act, it is clearly mentioned the definition India, which was removed just to avoid the controversy was there, which is considered to be the term India considered as being Indian slavery or the colonial Indian slave. That's why it has been removed the word, and again it is supported by the Constitution of India through Article 1. Then again, we can say that Section 22 of the Act, that is Indian Evidence Act, which speaks about oral evidence and or admission orally whenever someone is producing any document or any other evidence which is on the basis of oral admissions, and if it is related to electronic document, then it has to be proved through electronic way, which is recently introduced, and the previous section was removed. It has to be produced a document which should be not oral admission, but it has to prove through the digital record. That means if someone is saying that he has seen that X person has passing through and he has seen it from CCTV footage or any other electronic media, he has to show that footage instead of just orally admitting that he has saw the person who is passing, and that is through CCTV footage. So that was here inserted in the new law, whereas the previous one, mere basis on the oral admission, have been removed. If you are going to section 82, that is also removed from the new Bharatiya Saksha Adhiniyam, which is related to presumption as to document which is admissible. It is again showing that how the colonial command was there in India and how the courts were not free. The Indian courts were not free. It was also controlled by the England government, because whatever the document which has been produced from the England, that has to be considered as an original document without having the seal or signature. So that is totally scrapped from the new act. And new act, that is in the Bharatiya Saksha Adhiniyam, it is not appear. Then again, if we see about section 88 of the new act, old act, it is considered to be the presumption as to certified copies of certified presumption as to telegraphic messages. Telegraphic messages means currently the telegraph department is not working. That's why it is non-functional. That's why these are also have been removed. So whatever the telegraphic message or something which would not be considered to be a part of an evidence according to section 88, which was there in Indian Evidence Act and which is not there in Bharatiya Saksha Adhiniyam. Now if you go to section 113 of the Indian Evidence Act, which speaks about proof of station of the territory, which is related to the territorial jurisdiction, which is considered to be earlier, it was related to the proof has been proof of the territorial jurisdiction, that is not related to any kind of state or something, that also have been removed. Then section 166 is also there, which is removed earlier, which is related to power of jury to interrogate or to question during the trial going on. But now we can see that there are the bench, division bench, single bench, and there are the judges. There is no jury right now in function. That's why this particular section also have been removed. Again, if you go through the proper comparison, the second type, that where we have to focus, that is, it is in comparison with, there are several other comparisons that I have already mentioned about. It is there in the Ware Act, but we are not focusing all of them. Otherwise, it will take almost 3 hours to mention it. Now, if you have proper comparison in the earlier act, that is in Indian Evidence Act, there are only 3 parts, and 3 parts plus 11 chapters was there. Whereas in the new act, that is Bharatiya Saksha Adhiniyam, in case we can say that the BSA contains 4 parts plus 12 chapters. So in first part, it is considered to be in Indian Evidence Act. It was there. It is related to section 1 to 55, whereas only 2 sections are contained in new law as to be considered as a preliminary part. The second part is there. It was in Indian Evidence Act, which was related to proof, and that was right from section 56 to 100. Whereas the second part of the Bharatiya Saksha Adhiniyam, it speaks about the relevancy of fact, which again start from section 4 to section 3 to section 50, which is related to the part first of the previous act, which is being changed into the second part in the BSA. Then if we go through part third of Indian Evidence Act, that was related to production and effect of evidence, and that was dealt in section 101 to 167, whereas section 21 to section 103 or 103, that is considered to be part third, which is related to proof, on proof, which was the second part in Indian Evidence Act, and in BSA it is a third part. The fourth part was introduced in the new act, that is production and effect of evidence, which is from section 104 to section 170. So it was in earlier act, there was 167 sections, whereas the new act introduced or added 3 more sections, that is up to section 170. Along with that, in pursuance with the new schedules has been introduced, which is related to certificate. Certificate, which is given in part A and it is given in part B. So part A is related to whoever party is producing a document, which is the document related to electronic way or digital documents are there. then they have to certify for the relevance of that document plus reliability over that document. Plus, the part B speaks about the same document has to be certified by the expert if he is giving an expert evidence. Like example, there are several other experts, not medical expert, but those who are related to techno-savvy experts, or those who are dealing with the technical things. Then whenever they are submitting any of the document, they have to certify it first. Then only they can submit it to the court. That has been introduced in Bharatiya Saksha Adhiniyam. Now, if you are going through the principal provisions, which is brought before us and which was being introduced in a new way or in a new form, we consider that section 2, which is related to the definition clause, or which is the definition. Clause D is there, which speaks about the term document. So it was earlier also there, the term document was defined, but it has and that the document which is electronic record also considered as a document. It might be any video, it might be a call, it might be or it may be anything like CCTV footage or something, some encrypted messages, whatever, they will be considered as a document because they contain or they are being electronic record. Again, in the same section, in the same clause D of section 2, it has been explained or added an illustration. It defines what exactly the documents which is considered to be electronic record with respect to illustration 7 is there, which speaks about electronic record, what is to be considered, that nothing but emails, server logs, then documents on computers, that is computer files, then laptop or smartphone, messages, websites, locational evidence, and voicemail messages which is stored or stored on digital device are considered to be a document because they are to be considered as E or D digital record. That's why they has to be named as document. Now, section 2 plus E provides a definition which is related to evidence. It was the same which was there in earlier law, but newly there were 2 clauses has added. That the second clause speaks about what is exactly evidence also. It is also attached in the document if the electronic or digital records produced for the inspection of the court are also called documentary evidence. So it speaks about a documentary evidence. Then section 23 is a very important section. It was there in Indian Evidence Act. That was right from section 25 to section 27 was dealt with, and which is very near to everybody's heart, those who are doing practice and those who understand the evidence. That is, but confession made before a police or any statement which is made before a police, whether it has to be considered to be admissible or it is a confession. According to section 25 of Indian Evidence Act, whatever statement has been recorded by the police officer should not be considered to be admissible and considered to be a conclusive proof. That was there right from section 25 to 27, whereas all these 3 sections has been consolidated into one, and section 23 speaks about the same. So instead of 3 sections were there, they have been consolidated into one right now in Bharatiya Saksha Adhiniyam. And we can say that section 32 is there, which is related to relevancy of statement as to any law contained in law books, including electronic or digital form. Here, the weightage is given not only to the document which is produced before the court, but there are several other books, journals, those are not in the physical form, but in an electronic form also. So whichever the journals are there, which are considered to be law journals or which are considered to be electronic e-books, they must be considered as it is a relevancy of statement which is recorded into those books has to be considered as a document. And it is given and introduced newly in section 32 of the Bharatiya Saksha Adhiniyam. Then section 57 is there, which deals with primary evidence. If we are going through the types of evidence which was there in previous act and same is continued in the new act, evidence are primary, secondary, oral, hearsay, whether it is admissible or not admissible, documentary, and the old documentary. So these all are the types of the evidence. So here this speaks about primary evidence, what can be considered as a primary evidence. So it has given, the definition is remains same for whatever it was given in earlier law, but only it has introduced 3 more additionally. There was 7 explanations are given that what are the other evidences are also to be considered as a primary evidence. So there are 7 sections are there. Out of 7, the 3 are principal sections and which we have to focus on and which is newly introduced. That is explanation 5, explanation 6, explanation 7 is there. So explanation 5 speaks about if any electronic or digital record is there which has been produced from a proper custody before a court as a primary evidence. From a proper custody means it is neither tampered or which is regular or which is not like a fabrication of evidence. So whatever, and that is from the proper custody if it has been received. Like example, there the government portals are there and the data which is fed into the government website or something and it is in the proper custody of the government or any other custody of a private individual, then in that case, if it has been produced before the court, then that would also be considered as a primary evidence, subject to the condition unless it has been objected with respect to the tampering, destroying, as well as fake or fabrication of the evidence, and it is still proof, it would be considered as it is a primary evidence. Then explanation 6 is there, which speaks about if video recording is there, which is broadcasted or stored, will be considered as a primary evidence. And explanation 7 also, which deals with all automated storage, including temporary files, are also considered to be primary evidence. So again, if we see that the evidence which is related to primary one has given a widened scope and it has been more elaborated than the earlier law. What can be considered a primary evidence? In addition to this, one more thing is there. Whoever producing the document which is in the e-form before the court, he has to provide a certificate. That what I have already given a reference of a schedule, that is part A and part B, which speaks about the format of a certificate. Into it, he has to mention his name and everything. Plus, he has to mention that from which source or from which device, the source, whatever the source is there, from where he has received that information and to be considered as an electronic record. Like example, the IP address of the device or IMEI address of the device plus back ID of the device. So these all are to be considered as the electronic record, and it has to be certified by the person with respect to digital evidence, and it has to be recorded, and from which source it has been generated has to be considered along with the model number of that particular device from where it has to be received, and he has to sign first of all, because to authenticate the document which has been produced, this kind of information has to be given and gathered from the person one who is producing before the court. It may be either party or maybe an expert. For both of them, this is needed and it is compulsory and it is attached to the schedule. So if the expert is providing such evidence, then he has to go through part B, which is related to schedule, and a party when is providing same evidence, then part A is there. As well as it has introduced that section 61 is there, which is related to electronic or digital record. While giving the electronic or digital record along with this certificate, there's a declaration has to be made by the party, whoever is producing this record. So the record would be CCTV footage, whatever the record will be there. So the record can be considered, and it has been elaborated in section 61, which speaks about it may be a mobile voice call, it may be video call, or it may be CCTV footage or some recordings. or anything. So they have just elaborated in section 61 along with the help which is supported in section 63, which speaks about hash value. Now, this is a new concept which has been introduced, which is related to hash value. Hash value is specifically a professional can only given to the code, which is related to a numeric length of a particular, we can consider that the hash value is nothing but representing large numeric amount of a data, which is into the smaller, which is much be smaller numeric value. This is actually the explanation of what exactly hash value that you, me, and him cannot provide. Only an expert can provide with respect to hash value, because he is an expert and he knows that how to draw that particular value and has to be produced. That's why section 61 and section 63 are considered to be complementary and supplementary to each other with respect to providing any kind of record which is in the form of electronic or digital. And again, this particular section speaks about a digital signature also. If you are going through section 170 is there, if we are looking into this particular section 61 and section 63, there was a judgment in 2014 was held by the Supreme Court in Tomaso Bruno and another versus State of UP. It was held by the Supreme Court that it is clearly stated that CCTV footage is the best evidence. We Indians are great fan of the cricket, and entire world is relied on fourth umpire decision, which is nothing but a footage or recorded. Why not judicial? And it is a best evidence which was already stated in the judgment which was delivered by the Supreme Court in 2014 and which is supported in the new act. As well as we can say that section 170, that was the last section which speaks about saving and repeal. If you're going through all those sections, right from definition, then the provision, then the part, then chapter, plus the repeal and saving at the end, these all are the internal aids of interpretation of a statute. And through that, it is added the last column, that is saving and saving clause, repeal and saving clause. Repeal means according to this particular section, it speaks from 1st July. The 1st July Indian Evidence Act has been repealed hereby entire. But any matter pending before implementation of the act, any trial, any proceeding, any appeal, whatever, it would be followed according to section, according to Indian Evidence Act 1872. It would not be hampered upon the any kind of issue would be there with pending matters. That was mentioned in the saving and repeal clause. Last but not least, I must conclude this and say that as we are going to the next generation, which is nothing but digital, and that's why to support the digitalization plus to support the need of the time and the society, Bharatiya Sakshya Adhiniyam has introduced several other changes with respect to e-record and digital records or any other thing which is related to electronic media. Because if we see that the Information Technology Act 2000 is considered as inadequate little bit, which is related to e-documents or something, but which has given a support in Evidence Act specifically. That's why I here conclude the topic and consider and say thanks to everyone for listening me very patiently. If any other questions are there, I'm here to answer.
Thank you so much.
Guru.
Participants, do you have any questions?
Sir, I would like to ask one question.
Yes, please.
Sir, can we attest electronic documents?
E-attestation, sir, there is a digital signature is there. If you can do the digital signature, then it can be attested. But if the certificate is provided by the person one who is producing the document, it is nothing but considered to be an attestation because he is undersigned the same.
Actually, I have got one letter from one department
Okay.
through email.
I'm not able to hear you. Sorry, sir. Can you just
My
speak loudly?
officer does not I have got one letter from authority
Okay,
on
sir.
email. On email.
On email. Okay.
Actually, it is signed by formal sign, not digital sign. I have received one email,
Okay,
and
sir.
in that email, there is one decision. The employer does not attest this document. He is saying that he is electronic document or email.
But-
You can bring the original document.
If you are sending the original document, then if you are not attested selfly, because the self-attestation is nothing but it was earlier law, sir. I'm not getting your question that you have received the email from
Yes.
from the authority. Is it a judiciary,
Yes.
sir?
From one authority. Yes. No, no, no.
Madam,
It is actually
Harshada
commission.
madam,
Sorry?
excuse me, Harshada madam, it will be better if he asks the question in the chat box and you also respond in the chat box. It will save everybody's time, please.
Okay, sir. I'm sorry, sir. I'm not able to
Yeah,
hear
yeah,
him properly.
yeah.
His
That's
voice
why
is
I request the participant to ask the question in the chat box, please.
Okay, okay, sir. I will. Sir.
Okay. So, thank you, ma'am. That was indeed a
Thank you,
very
sir.
session. Ma'am, we are incredibly very proud that you are our alumni, and it was such an excellent, excellent guidance, ma'am. So, thank you once again for sharing your insightful knowledge on the New Evidence Act, Bharatiya Sakshya Adhiniyam. Thank you once again, ma'am. Moving forward, I would like to invite one of our students, Ms. Chetna Kare, to introduce the resource person for this session, Dr. Anand Deshmukh. Chetna,
Good morning. Good morning. Yes, I am here.
yeah, over to you.
Good morning, Mr. Persons, chairpersons, all the coordinators, and all my dear. It's eager to introduce our today's resource person, Dr. Anand Deshmukh. With his great knowledge, he is designated as professor and head in Department of Postgraduate Studies in Law in Dr. Babasaheb Ambedkar University at Chhatrapati Srinagar. Specialization Criminal Corporate Law. Also called in Indian Constitutional Law. He is also on the board of Pune University and Babasaheb Ambedkar University, Chhatrapati Sambhajinagar. He has done his doctorate in human rights perspective of victim status in Indian criminal justice system. With his deep and boundless knowledge, he has qualified his NEET in first attempt. He also worked as a panel member in Maha Adalat and participated in various state, national, international.
Hello, Chetna.
Anand Deshmukh, sir, you can take the charge now.
Yes, sir.
We request
Yes, I
him to
joined,
please
sir.
guide us.
Very good morning to all of you.
ऐकूच नाही आलं का
Chetna,
मोबाईलमध्ये?
it's okay, it's okay.
Yes, sir.
Chetna, now you mute yourself. Yeah, Anand Deshmukh sir is presenting. Yes, sir. Anand sir, you continue.
Okay, sir. Thank you, sir. Thank you very much, sir. Sir, very good morning to all of you. Honorable Principal Dr. Vijay Bhairam, sir, other teachers, and my dear students. As Dr. Ambedkar Law College, Dhule, organized this national webinar, especially on the 3 amendments and which were implemented from 1st July 2024. Sir, I hope my voice is audible.
Yes, sir. You are clearly audible. Yes, sir.
Okay, sir. Thank you, sir. Thank you, sir. Thank you very much, sir. And sir, I also apologize, sir, because today coincidentally
sir, I know that you are very
sir, at the
busy.
same time, and that's the reason I prepone my time, sir. As my friend Dr. Bhairam, sir, asked me to deliver a lecture on Bharatiya Nyaya Sanhita. So I like to confine myself about only that Bharatiya Nyaya Sanhita, an old one, it's a Indian Penal Code. As sir told me, number of the participants are the students of our law college. From that sense, I tried to tell them what was the IPC and now what changes brought by our central government by way of this amendment, which implemented from 1st July 2024. As you all know, this draft prepared by Dr. Ranbir Singh, who was the former professor and Vice Chancellor, National Law Institute, New Delhi. And according to his draft, this new change is brought by our central government regarding these three code, Indian Penal Code, Criminal Procedure Code, and the Indian Evidence Act. This IPC now known as the Bharatiya Nyaya Sanhita. My dear students, what is the meaning of this codification? Why it was termed as the Indian Penal Code? Because codification is nothing but the reduced into writing. And what is the purpose of this codification? To bring the uniformity. That's the reason they use the code. Criminal Procedure Code, Civil Procedure Code, even the Hindu Code Bill. So in the way, Indian Penal Code, and this IPC was adopted by Lord Macaulay in 1834, and same was passed by British Parliament in 1860. And subsequently, that code was enforced entire India from 1860 to till today. And as you know, this is the code which is leastly amended by our government. What I feel there was no need to amend the IPC, it means he cleverly drafted the Indian Penal Code. When we try to trace the history, what we observed in our country, in ancient India, that Varna system was prevailing. And as per that Varna, the person who hanged the higher Varna, lower punishment, and lower Varna, higher punishment is there. And during the period of Mughal, again, that punishment was discriminated on the basis of religion. But after the arrival of Britishers, again, one more reason which compelled the Britisher to pass the code in 1860, that the mutiny which took place in 1857. And that's the reason they failed. It is a necessity to have a separate code to suppress the vice or to maintain the law and order in India, which was one of the colony of British or British India. And ultimately, in 1860, that Indian Penal Code passed by the British Parliament and that came into enforcement from 1860 to this. Means what I like to say that it is my own opinion, my observation. I feel the credit goes to the Britishers to establish the uniform criminal justice system in India from 1860. Otherwise, prior to that, there were the discrimination, either on the basis of caste, either on the basis of religion. But once this code passed, that brought the uniformity in entire country. Suppose a person who committed the offense of theft, you know, the maximum punishment for offense of theft is 3 years. Then irrespective of the caste or religion or status of person, the punishment is same. And why it was possible? Only the Britishers who did such act. And that's the reason, it's my clear opinion. The credit goes to the Britishers to establish the uniform criminal justice system in India. And another thing I like to suggest, in 2000, the one committee was appointed by the government of India to suggest the reforms in the existing criminal justice system, and that committee was known as the Justice Mullimit Committee. And that committee comprises 12 members who submitted the report in 2003. I like to mention one more thing here, that Justice Mullimit Committee didn't dare to touch to the substantive law. It means IPC or Indian Evidence Act. They may suggest some of the changes under the procedural law. But instead of all those things, our central government decided to take a decision to have some kind of amendments, or what is that, major amendments under these three codes. And again, they amended and they renamed all these three laws. But basically, what we know is the title of law should be in English. But what you observe, the title of this law should be in Sanskrit. This is contrary to provisions of our constitution. This is another blunder. And one more thing I like to suggest, whenever government takes such kind of decision to make any kind of changes, what they should do, they refer the matter to the Law Commission of India. But instead to that, they refer the matter to a former professor and who served as a Vice Chancellor of National Institute of Delhi. It's a blunder on the part of the government, because Law Commission of India is a competent authority who has entire power to make such kind of changes or to suggest their changes, and accordingly government take such kind of decisions. But these are the changes which made on the recommendation of a draft prepared by Professor Ranbir Singh, who served as a Vice Chancellor of the National Law Institute. And one more thing, when this bill brought on the floor of Parliament, first time in the history of India, 146 members of Parliament expelled from the House of Parliament. And there was no discussion, no common consensus. What I feel, if these bills were passed unanimously, it would mean have more weighter, where it means there should be some kind of discussion. And then only government should take such kind of decisions. Sir, my voice is audible? Because what I okay, yes, sir. Thank you, sir. Thank you. Instead of that, they should refer this bill to the select committee. But now it is implemented. So no meaning to discuss what the government did. We should accept it. Now it is the law of our country. And now I switch to this Bharatiya Nyaya Sanhita. What are the changes brought by this government? Initially, under IPC, as I told you, this code adopted by Lord Macaulay in 1834 and same was passed by Britisher in 1886. Under old IPC, there were 511 sections which were divided into 23 chapters. And one more thing I like to share. Honorable Home Minister, Mr. Amit Shah, who made a statement on the floor of Parliament to state what is the intention to amend these laws. He stated that the intention was Britisher to punish the wrongdoer, but our intention to give the justice. And that is his contention to support what is the need behind to make some kind of changes under these three codes, IPC, Criminal Procedure Code, and the Indian Evidence Act is there. So under old IPC, there were 511 sections which were divided under 23 chapters. But under new Bharatiya Nyaya Sanhita, there were 358 sections which clubbed together under 20 chapters. It means they reduce the strength of sections, number of sections from 511 sections to 358 and from 23 chapters to 20 chapters. Again, they were inserted, 31 new offenses were added, and at the same time, 19 offenses deleted from this Bharatiya Nyaya Sanhita. When this IPC turned to change to the Bharatiya Nyaya Sanhita, one more thing, in 41 offenses, punishment is enhanced. Means they impose the maximum punishment under 41 offenses. One more thing, in 6 offenses, community service is added as a form of punishment. My dear students, you might be studied under criminology, penology, as well as IPC. Under old IPC, section 53 states about the kinds of punishment or types of punishment. So there were 5 types of punishment, including a death sentence or a capital punishment, life imprisonment, simple or a rigorous imprisonment, fine and forfeiture of property. And in addition to that, one more form of punishment inserted by our government in the form of community service. Samajachi Seva Karni. Earlier, this provision was found under the Juvenile Justice Care and Protection Act. So, 6 punishment added in the form of community services. Now, this is the new form of punishment. But exactly for what offenses or what is the form of this community punishment is not mentioned under the IPC. But this is what I feel is a welcome step on the part of the government. At least for the petty offenses, the competent court may impose the punishment in the form of a community service and ask that wrongdoer to do some service of the society. This is one more thing. And then this amount of fine is also increased. As we know, earlier under IPC, the amount of fine was so meager, 50 rupees, 100 rupees, 200 rupees or like that. But nowadays, that fine enhanced from 10 lakh to 1 crore in more than 80 offenses. From 10 lakh to 1 crore for 80 offenses. This is the fine. Maximum punishment is also enhanced for 41 offenses. Then, what I like to tell you that some of the new offenses enlisted into this IPC, into this Bharatiya Nyaya Sanhita. Earlier, तुम्हाला माहित आहे, offenses against women, offenses against state, economic offenses, like that. Those offenses were to be divided under 23 chapters. But in this Bharatiya Nyaya Sanhita, they added new offenses in the form of terrorist act, organized crime, mob lynching is also there. Means Amit Shah, you observe on the floor of parliament stated that we added the punishment for the mob lynching, and we know some of the incidences which took place in our country where on the doubt or suspicion the person carries the meat of a cow, that person was lynched by a mob. And for that purpose, to prevent such kind of offenses, the new offense enlisted under the Bharatiya Nyaya Sanhita in the form of mob lynching. But when you talk about the terrorist act, this mob lynching or the organized crime, what I personally feel that to tackle the offenses of terrorist or terrorist activities, and in our country, there are the special laws or special legislations are there. You know, TOTA, TADA, and now Unlawful Prevention Activities Act is to. But this is a special law which deals the matters of a terrorist are there. If that law is there, then what is the intention of the part of legislature to insert such kind of offense under the Bharatiya Nyaya Sanhita? This is a question before. Another thing, organized crime, as we know. Again, Mokoga is there. Syndicate crimes. To tackle, to deal such offenses, every state will crime, their own laws are to be there. But again, these laws also, these offenses also mentioned under the IPC to prevent such kind of organized crime, or you may say that syndicate crimes are to be there. Then another thing, the inchoate crimes. This is a separate category inserted under the Bharatiya Nyaya Sanhita. This is a good thing. We know that while committing offense, sometimes more than one person involved into a commission of a crime, then the question may arise, how to fix the criminal liability, the person who involved into a commission of a crime, that is inchoate crime, or what is stated, parties to crime. So under one head of inchoate crime, they inserted, they clubbed some of the offenses under the head of abatement, a conspiracy aligned that. Earlier IPC, we observe this offense of abatement under section 107. And another thing, conspiracy. Though that conspiracy is also one of the ingredient under section 107 of the old IPC, but by way of amendment, again government inserted the offense of conspiracy under chapter 5A, and only two provisions were there, section 120A and section 120B is there. Why I'm telling you, some reason is there. Please try to understand. Under section 107, there is also conspiracy is one of the ingredient where that conspiracy is liable to punish under the head of abatement. Again, the number of persons involved into commission of a crime. Then what was the need on the part of legislature to have a separate provision under section 120A and punishment 120B, where the punishment was in the form of death sentence. But when we observe that conspiracy under the head of abatement, what we observe, some kind of an overt act is essential one to punish the wrongdoer for the offense of conspiracy under the head of an abatement. But under section 120A, what is stated that, what was stated that when two or more than two persons agree to do an illegal act, to do an legal act by illegal means, such an agreement is designated as a criminal conspiracy. Means mere agreement or meeting of minds for the just to punish the wrongdoer. And that's the reason in Indira Gandhi assassination case, when one of the suspected, K.R. Singh, was sentenced to the death, then Minu Masani was criticized that it was the judicial murder. How a person can punish on such kind of a doubt or evidence is to be there. It was history, but now under the Bharatiya Nyaya Sanhita, these offenses club under the head of inchoate crime, either the abatement and conspiracy, where more than one accused person is involved into a commission of a crime. Second category is most important one, offenses against women and child. Again, these offenses are clubbed together under the head of offenses against women and child. Again, I like to mention one more thing. In old laws, specifically the sexual offenses, these offenses were the gender specific. Means it was presumed that only man is liable to punish for such kind of sexual offenses or sexual assault, and woman is not liable to punish. The same way, under Bharatiya Nyaya Sanhita, these sexual offenses are the gender specific, except one offense, that is a voyeurism. Voyeurism, where we observe that, we know that to observe the sexual acts of a person without the knowledge. Here, might be woman is liable to punish, but in rest of the offenses, these offenses are the gender specific and man is not liable to punish. As we know, under section 375 of old IPC, which defines the offense of rape, and they clearly state that a man having a sexual intercourse with a woman under certain exceptions, there are certain circumstances, and then such a man is liable to be punished. Still under the Bharatiya Nyaya Sanhita, these sexual offenses are the gender specific and not the gender neutral, except the voyeurism as under section 354B is there. Then section 377, that is the under old IPC, we state that the unnatural sexual offenses. And we all know in historic judgment in Navtej Singh Johar versus Union of India, Supreme Court decriminalizes that section 377, but under certain circumstances, still that was an offense. So under Navtej Singh Johar versus Union of India, what the Supreme Court stated that this is not an offense, especially under the circumstances when there is a relationship between the two consenting adults. They use the word two consenting adults in a private. Then law don't have any reason to peep into their personal affairs up to that extent that section 377 was decriminalized by Supreme Court in Navtej Singh Johar versus Union of India. But again the consent and again the offense of child, again the child, that was an offense. But under the Bharatiya Sanhita, Government of India decided to delete this provision from the new code. It means now unnatural offenses is no more an offense. As we know, bestiality, sodomy, or unnatural sexual offenses are. Or against the order of nature, earlier that was an offense. I think this is also a good step on the part of the government. Earlier, there was a harassment on the part of such a person, especially the transgender, gay relations, lesbian relations. That was an offense, but now this is not an offense is to be there. The government left it to the consensus of the common man or inner conscience of the society is to be there. So this is another important change brought by the central government under the Bharatiya Nyaya Sanhita. So when you talk about the sexual offenses, you try to understand the most important thing is that still in India, these sexual offenses are the gender specific. No woman is liable to punish for the offense of rape is there. And might be that is the reason the government decided to pass the separate act in the form of Protection of a Child Sexual Offences Act is there. And they replace the word rape with the sexual is there. That is another special law to protect the child from sexual assault is there. But still under the Bharatiya Nyaya these sexual offenses are the gender specific offenses. And one more change. Earlier section 124A, which states about the sedition. And in number of cases, Supreme Court stated that it is the time to revoke or to delete this provision. And what the government did, instead to sedition, they replaced that provision under section 150 as a treason. Rajdroh च्या नावाखाली आता देशद्रोह आलेला आहे. And what they did, they enhanced the punishment for the offense of treason under section 150 is there. Though the Supreme Court clearly stated that to repeat this provision. And another changes is like that, hit and run punishment. Section 304A, that negligence, we know the Salman Khan's hit and run case. But now, increase the punishment for causing death in hit and run cases from a maximum of 2 years to 5 years. आधी 2 वर्ष होती, आता 5 वर्षाची शिक्षा करण्यात आलेली आहे. Then the offense of theft, which mentioned under section 378, now that theft earlier was restricted only to immovable property, but now they change the nature of theft and includes the theft includes digital items, includes data theft and identity theft. Nowadays, in a digital era, the data is the most important one, and whoever is responsible to commit the theft of data, that person will have to punish or prosecute for the offense of theft under the Bharatiya Nyaya Sanhita. Same way, medical negligence is there. There are specific provisions have been added to address medical negligence. As we know, Supreme Court stated that when the medical practitioners are liable to punish, and earlier under general exception from section 87 to 93, that protection was conferred to the medical practitioner to protect them from such kind of acts. But now there is some kind of changes to fix the liability on the part of medical practitioner on the basis of negligence. Earlier stated, the Supreme Court stated that unless and until there was or there is a gross negligence, medical practitioner is not liable to prosecute criminally, though he is liable to punish or to pay the compensation. But now, according to this Bharatiya Nyaya Samhita, they address the medical negligence. Another important thing is that economic offenses. The term economic offense is now specifically defined under the Bharatiya Nyaya Samhita. It means they brought some kind of changes, but still some query raised in our mind. What is the need on the part of legislature to have such kind of changes under the IPC? We know that the change is the rule of nature. We expect to follow some kind of changes, but I feel it may have some time, or they may refer such and where there have some kind of discussion or common consensus, unanimously, that would have more a better, and that is the reason Madras High Court judge criticized about this title of the this Bharatiya Nyaya Samhita, and who stated that I use even in future also Indian Penal Code, and they also raised the question mark on the intention of the legislature why they made such kind of amendments. If they felt they may make some kind of amendments under the particular provision, and no need to amend the entire things. And what I feel that they give enormous powers to the police, and that may result into the misuse of power. So our intention of constitution to establish the welfare state, it may not turn to a police state. That is the only expectation with these changes are to be there. But what I feel, maybe some changes are welcome changes on the part of the legislature. Might be they have to take more precaution while implementing these provisions under the IPC. I hope this is the little bit things about the Bharatiya Nyaya Samhita. And lastly, I like to express my sincere thanks to Honorable Principal Dr. Vijay Bhairam sir, who invited me and who also forgive for this inconvenience to prepone my time. I hope the student may understand little bit about the changes brought by the central government by way of this Bharatiya Nyaya Samhita. Earlier, it was Indian Penal Code, and now it is the Bharatiya Nyaya Samhita. Once again, I express my sincere thanks to all the participants and my dear colleagues. Thank you very much. Yes, sir.
Thank you so much, sir. Thank you, sir, for an exceptionally insightful and informative session. If anybody has any questions, they can ask in the chat box. Sir, we appreciate your for sharing your expertise on Bharatiya Nyaya Samhita and Indian Penal Code, sir, and for guiding us through detailing the changes in new criminal laws and the old ones, sir. So thank you so much, sir. It was really informative for me.
Thank you very much, sir. Thank you, sir. Thank you. Can I leave, sir?
Yes, sir.
Thank you very much, sir.
Yes, sir. Thank you, Anand, sir. Thank you. I know that you are very hurry. You are in hurry.
Thank you. Yeah, sir. Thank you very much, sir.
So moving forward now to our last session, the next session and our last session, I would like to invite one of our students, Miss Nilakshi Suryavanshi, to introduce our third resource person, the last resource person for today's workshop, Dr. Rahul Nikam, sir. Nilakshi?
Yes, sir. Good morning, everyone. It is my honor, esteemed resource persons, for today's National Virtual Workshop on New Criminal Laws, Professor Dr. Rahul J. Nikam. Dr. Nikam is an Associate Professor of Law and the head of the department at the Faculty of Law, Marwadi University, Rajkot. He also serves as the UGC NAC coordinator, demonstrating his commitment to the academic excellence. Dr. Nikam earned his LLM degree in corporate laws in 2008 and went on to receive his PhD degree in 2012 from the prestigious Nalsar University of Law, Hyderabad. His impressive academic journey reflects his deep dedication to the field of law and legal education. Currently, Dr. Nikam's research interests are vast and varied, including law, science and technology, corporate laws, policy reviews, and the administration of law and policy. His work not only contributes to academic scholarship but also provides significant insights into contemporary legal challenges. We are very fortunate to have Dr. Nikam with us today to share his knowledge and expertise. Please join me in welcoming Professor Dr. Rahul J. Nikam. Thank you.
So thank you so much. Am I audible?
Yes, sir. You're audible.
Yes, sir. So before starting, I would like to do Dandavat Pranam to my mentor, my guru, Vijay Bhairam sir, Sabnis sir, Sarunke ma'am, Sheikh ma'am, my senior Daga Patil, आणि आमचे आदरणीय प्रेरणास्थान निळे सर, त्यांच्या वाचून आमच्या धुळ्यामध्ये लॉ कॉलेज नसतं, ते आहेत म्हणून आम्हाला एवढे सगळे आमचे गुरुवर्य इथं भेटत आहेत आणि त्यांच्यामुळेच आज जे मी काय आहे हे सगळं क्रेडिट त्यांनाच जातं. तर अगेन माझं दंडवत प्रणाम टू यू सर, बहिराम सर आणि सगळं माझं शिक्षक वृंद. काही चुकलं मापलं तर मला माफ करा. Because this is the first time I am just presenting before my guru, so let me try my best. So hope you people are able to see this particular PPT. And before starting, let me raise my dissent voice with the earlier speaker, and especially with the 2 points which I was not agreeing, because I myself is a part of this very much 3 particular code which has been changed, discussed, deliberated. We have gone through with more than 5 lakh comments, because Ranbir Singh sir is my mentor. And for your information, Professor Vajpayee, who is the renowned person in the whole Indian fraternity, he's like a Bhishma Pitamaha for the criminal law and all the 3 laws. Like we say na, our Bakshi sir is the god for our constitution and law side. The same way, criminal law, Vajpayee sir, who is the present NLU, he is also my mentor, and I have worked very close under his guidance, and also with Ranbir Singh sir. Now coming to the second point, see, these words what they have used for all the 3 are very much aligned with the letter and spirit of India, that is we call Bharat, which is mentioned in the constitution itself. And we should not subscribe to the people alien to us who has given this world so-called India, that is INDIA. Now coming to the third point, which I want to clarify here, is that it is not the government intention who has suspended 146 so-called people's representative in the parliament calling themselves as a MP. It is because of their non-cooperation, it is because of their lack of commitment to the new changes which government is trying to make it aligned with the 21st century techno-savvy crimes. Let me put it very clear here. What I am telling here is that we are living in a 21st century where crimes are also now had changed its nature. So law need to change its nature. And coming to the next, I would like to add that it is the Law Commission had also given its concurrence, complete decision to the reports which were submitted under the leadership of NLU Delhi, followed by NALSAR, followed by NLSIU Bangalore, followed by all the legal fraternity, followed by all the judges, whether retired or present, who are directly on the dais and leading it from the front, the justice delivery system in criminal side. And after that, it has gone again 3 more changes in the Home Ministry itself. And then when the committee has reviewed, then now the final version has came into the existence. So let's begin with this. So before this, I would like to tell you why there is a need to bring the CRPC repealed and to take the place of this Bharatiya Nagrik Suraksha Sahita. In short, in the next 20-30 minutes, I will be using the short form as a BNSS 23. So let me begin. So see, the CRPC regulates what? Arrest, investigation, inquiry, trial of the offenses under the IPC and other relevant laws. Now, what happens here is that the fast and efficient judicial system is an essential component of the good governance, and the delay of justice due to the complex legal procedure, large pendency in the cases in the court of law, lower conviction rate, insufficient use of technology in the legal system, delays in investigation system, inadequate use of forensic, very much important. Earlier, we do not have any kind of legal backup to the forensic evidences which are very much need in the procedural aspect of going through the facts and the figures and the convicts and the arrested and the victims, what kind of problem they have faced, and to lead them to the logical end. We call that a justice delivery. So we always discuss that there are two terminology, that a criminal justice administration was the earlier notion. Now what these three laws and especially this BNSS has got, administration of criminal justice. Now that emphasis has been brought to the administration, how it has to be delivered, how it has to be seen on the daily basis, right? It from, starting from the criminals, right? It, start from the victims, right? It starts from where it takes place, means that is the society, right? It starts with the police, right? It starts with the, court, and the end, that is the, victim protection as well, which was earlier lacking, which was very much lacking in the earlier context. So this is how is important. So that's why what government has tried to see here is that the motto of government is very clear. What is the mantra? That sabka saath, sabka vikas, sabka vishwas, and sabka prayas. Now, if you literally interpret these words, this particular 1, 2, 3, 4 words, these are been seen here. And let me give one precaution also. See, nothing, not even a single law is perfect in its nature. It's ever change. And why it is changed? The development which has been taken and which are going to take place on the daily basis, it forces law to take the amendments and make it convenient, relevant, and enforceable in the present context. So don't think that this is a full and final version, this is before us, because I can see we are working, I'm the committee member of the RBI, where we are working the digital UPI payment without internet. I am also on the committee with the ISRO, where we are saying that let's have commercial space application to be brought into the existence. Already I am with the committee with the national state government and central government. We are working on the AI and its implication and its uses in the criminal administration of justice and the financial law. And I am also part of the committee where we are going to have the e-court procedure and e-court proceedings. That also I am member. So very much insight is there with me, and I am talking it with very sincerity and with a great responsibility on my shoulder. So if we see what are the important changes, if you ask me to sum up, the summing thing is here that it provides the use of technology and forensic science in the investigation of the crime and furnishing and lodging of information, service of summons, etc. through electronic communication. Specific timelines have been prescribed for time-bound investigations, trial, and procurement of judgment, which is the need of the hour. And that's why we know that, sorry to my practicing side fraternity people, but we know that how much time and the technique and the tactics has been used to delay, to play around, to misuse, to stop proceedings, not to present in the court of law, taking lot of adjournment, taking lot of new dates, has resulted all those things. So there are one, as a law fraternity, we need to upgrade ourselves with the new jurisprudence regime. I must say that, because before 2023 there was one jurisprudential realm which discussed the old laws, and if you see the new jurisprudential realm which started from 1st July 2014, so here there are lot of jurisprudential aspects are also going to take place when we start implementing and when we see how the court are reacting and what way the landmark cases or jurisprudence are taking new shapes. and changing our ideology as well. So these are, certain things. So let's quickly have a brief. BNSS having 531 section against 431, and there are 26 new sections which are already there. Present law talks about 39 chapters, 2 schedule, and especially in schedule 2, they have added 2 more extra format of a form. If you see, these are, certain areas which are being there. So I will straight away talk with, line by line, what are the new things are there. So let's begin with the first one. The very most welcoming thing is audio video electronic means is clearly defined, means any communication device for the purpose of video conferencing, recording of the process of identification, search, seizure, evidence, transmission of electronic communication. Everything has been clearly brought into the picture, and this is how the most welcoming thing which we must address here. Second is the bail. They have also defined the terminology of the bail, which says that the release of a person accused of or suspected from the custody upon certain condition given by bond or bail bond. Now bail bond means what? It is the undertaking for release with surety, and if it is only a kind of bond, so difference is without surety. So with surety and without surety are the key word to differentiate the bail bond and only the bond. Now the another important aspect, the IT law is very much there. Crime are happening and there are lot of evidences which are available. Like example, if something is going on the road, passerby can simply start recording. So can that be considered as the evidence and can be brought under the process? That is the BNS process. Can it be treated as evidence? The answer is very much yes. And this is what the leapfrog jump from the old conviction to the up to date 21st century techno savvy. That all things are being brought here. So if you see the electronic communication, it incorporate everything. If you say written, verbal, pictorial, video content, and all things, including now smartphones are just becoming necessary. You cannot do away from that particular device. It's like we are wearing clothes, so we are having mobiles. So how useful those devices can be used and brought into the process where it can be considered as a law backing, law acknowledging process through the mobiles, and based on that evidences with certain parameters, there are parameters also. If it is been found by law that yes, it is fulfilling all the conditions, then the process can be completed and speedy trial can be taken place. So justice can be achieved very high speed. The investigation is also very important. Now, what is very important, earlier it was lacking. What it says that suppose there are contradiction in between the BNS language and some special law. So what here in the BNS says that special law interpretation will prevail on BNSS provision, and that is what the another beauty that which was lacking, but now it has been brought up to the law. So this is the one of the area. Now let's go to the second word. Now here is also very important, which was earlier lacking. Now what they say is that words and the phrases used in the legislation but not defined. So here IT law and BNS will be having the same meaning in the BNSS. So whatever the gray areas which were there earlier, we used to find that. So now those gray areas are being plugged in, and now there are no scope of escaping from this particular and play around with the terminology, with the new particular act. Now coming to the next aspect, criminal courts offense constitution, which talks about 6 to 20. These are the new changes they have done. So now this metropolitan area and magistrate concept has been abolished. So there is no concept now, everywhere it has been same. Now the special executive magistrate is also there. So they are being can state government can also appoint them any police officer not below the rank of superintendent of police to be known as special executive magistrate. Earlier this provision was not there. You see, I have in the bracket I have mentioned the old section, so I'm not going to say that is again, but you can visualize, you can read it from that. Now coming to the public prosecutor. So for the NCR, National Territory Capital of Delhi, now there they have brought the special public prosecutor and APP, especially for the NCR jurisdiction. If we now go to the section 19, it says that APP, when no APP is been appointed available, so district magistrate now has given power. So they are not required to wait for the government, please appoint and get this thing. 14 days notice is enough. Within 14 days, if state government is not appointing, not replying, then the district magistrate is now empowered to straight away appoint APP, and later on, it can be regularized through the remaining procedure back-end channels, through the court and the interaction with the state government. Now, here is also very much important, that is section 20. Now, in each district, so at the state level, there will be the director of prosecution, and then every district will have the director of prosecution, deputy director of prosecution, and assistant director of prosecution. Now, the beauty here is that they have clearly demarcated their role and responsibility as well. So now no one can hide, no one can simply say that this is not my responsibility, I will take care. So now the responsibility has been also very clearly defined. Now when we go to the next one, that 20.2, it says that a person shall be eligible who can become this DP, DPP and ADP. So, there are changes now. So, for the DP and DPP, practice as an advocate for not less than 15 years or has been a session judge, can be straight away appointed. For the ADP, minimum 7 year, a practicing lawyer practice is required, or the JMFC retired can be directly appointed as the ADP. Now, if you see the section 20, it also talk about omits the requirement of concurrence of the Chief Justice of High Court for appointment of DP or DP, because we have seen this was also one of the area where it used to take a lot of time, and judges used to take very lenient view, saying that okay, it is there is no hurry, there are a lot of financial burden on us, so we will think and give and then do. So now this particular hurdle has also been removed from there. Now, when we go to the next, that section 20, as I told you, that there is very clear-cut demarcation of the role and responsibilities mentioned, which was not mentioned earlier in the 25 of the CRPC. Now, when we go to the next, there are courts and powers that talks about 21 to 20. Now here what they says is that the power of the assistant session judge to pass sentence has been omitted. Earlier it was there, but now it has been removed. Now there are certain increases also in the punishment also. So if you see the comparison, now JMFC earlier it was only up to 10,000 can give fine. Now he can go up to 50,000 rupees, and judicial magistrate second class earlier 5,000, now it is 10,000, like that it says that. Now coming to the next, that is the sentencing cases of conviction of several offenses at one trial. So see here what happened, the judicial officers at the court has been left out with their discretion, and there was a chance of lot of other factors including bias or equivalent to the money, certain kind of things used to happen. So now what they have mentioned here clearly, that you cannot say that concurrent imprisonment, this particular word has been omitted by the word by default rule. This has been now clearly been clarified there. The punishment shall run concurrently in order. Now it requires the court to consider the gravity of the offenses and clearly order such punishment to run either consecutively or concurrently. Now you cannot simply say all those things. I think Disha don't do this pain using all those things, because other may be getting disturbed. So green color is there on PPT. Then the maximum punishment is also been increased. Earlier it was 14 years, now it has been put to the 20 years. Okay. Now coming towards the next, now that is the power of superior officer of police and aid to the magistrate and the police. That is 4 sections, now 5 sections are there, 30 to 34. So now what it says that 34 says that duty of the officers employed in connection with the affairs of a village to make certain report. Now here if you see the definition, that is the proclaimed offender includes any person proclaimed as an offender by any court Now see the scope, how the scope has been widened here. By any court or authority in any territory in India to which this Sahita does not extend or extend, means extraterritorial now jurisdiction is also been given there. So this is in sync with the BNS. If you see, the earlier speaker used to say na, that how this goes. So extraterritorial things are also been now brought into there. And now what it says that the act, if committed in the territories to which this Sanhita extend, would be an offense punishable under any of the offense punishable with imprisonment for 10 years or more, or with imprisonment for life, or all with dealt under the BNS. Earlier it was section 14 there. Now arrest of the person is very important. Now what here they say, when police may arrest without warrant. So there are two exceptions they have been made, that infirm and old age person who has crossed 60 years shall not be made arrested unless it has been concurrent with the deputy superintendent of police, then only they are being allowed to arrest. Otherwise, they are not being arrested. This is very much clear. Now coming to the 36, it says the procedure of arrest and duties of the officer making arrest. So now what happens here is that information of the arrest be given to relative. Now this was also missing earlier. So relative or a friend or any other person named by the person arrested. Because earlier police used to take these excuses and all those things, and then due to the lot of internal issues, we may not able to convey where we are, what for we are being, and in which custody, in which police station, which area. So now this particular issue has been again done away. Now if you see the section 37, it talks about designated police officer. So now information display is very much important. Earlier what happened, they used to simply tell that at the headquarter control room, that information will be displayed. But the problem is that those information was not most of the time up to date. The information was so narrow, so insufficient that the remaining detail could not be, make out of that particular, information. So now they have identified very clearly that it is the assistant sub inspector of police is having responsibility to maintain the information about the name, address, person arrested, nature of the offense with the charges, and it should be prominently displayed in any manner, including in a digital mode in every police station and at the district headquarter as well. So if someone is missing, or let's say that police has been, taken some person and now we are not able to locate in anywhere near to the near the surrounding police station or anywhere. So now you have got that at least idea where this information can be brought, and if the information is not there, so it is the clear cut violation of section 37 by the police itself. So that is what I was telling. I am not in concurrence with my earlier speaker. There is no police raj. If you see the BNSS, everywhere they have been put it into very four corner area. How much police can do, how much police cannot do. If police crosses this four boundary wall, then now the judicial officers are being empowered along with the citizen to reach the judicial officers to complain or to brought to the judicial officers notice how the police are misusing power, and now judicial officers are also bound to take that cognizance of the citizens and immediately act upon as per BNS followed by BNSS. So there is no concept called police raj. Earlier it was, now they have been brought with such a clarity that the police are being demarcated with a certain given power. If they crosses, you are having way outs, and all ways are legal way out, including obligations, responsibility on the concern authority, including judicial officers. So this is, one other distinct area which we need to understand. Now the another one, suppose if the arrest on refusal to give name and address, then what should be? So it can be released on bail or bail bond. Earlier it used to not happen because police used to then कि तुम क्यों नहीं बता रहे हो, बताओ, अभी नहीं बताओगे तो चलो पुलिस में डाल दूंगा, तो मैं कस्टडी में डाल दूंगा, फिर पता नहीं क्या क्या होता था. Then section 40, arrest by private person and procedure on such act. Now suppose people are there, police has not turned up, so people has caught that particular offender, and now the offender is in the custody of the civilian people. So what is the provision? Now provision here is that civilians are required to produce it or hand over that particular person who is in their custody within 6 hours, to the nearest police station, whether that police station has jurisdiction on the area or not. That is another beauty. Then what happens here is that, see the word also. So earlier what happened? Rearrest. So this shall rearrest word has been replaced. Shall take him to the custody by police. So this terminology now has been omitted. There is no such a rearrest concept. Now they have been very clearly demarcated and diverted this procedure and the ideology, jurisprudential aspect, that shall take him to custody. And the word shall demarcates what? You know very well if you have gone through with the interpretation of statute, this particular act. Now coming to the next, arrest how to make. So earlier, now this, whether when we arrested person, should we immediately put handcuffing, or should we simply take him in the hands in hand and let's take him? So this clarity was not there. Now the clarity is very much mentioned in this. So what it says that police officer may, keeping in view the nature and the gravity of the offense, use handcuff while making the arrest of a person or while producing such person before the court who is now see, they have demarcated in which situation handcuffing is made or is allowed to made. Apart from this, now is the gray area, which once the cases are there and how the court is responding, we will come to know. Apart from that, whether there are other nature of offenses are also there. So what are the offenses where handcuffing can be made? That is the habitual or repeated offender who has escaped from the custody, who has committed offense of organized crime, terrorist attack, drugs related crime, illegal possession of armed ammunition, murder, rape, acid attack, counterfeiting coins, currency notes, human trafficking, sexual offenses against children, or against the state. So these are the area where handcuffing can be immediately made, and also while taking him to the court, you can use handcuffing. So these are the clarity that has been brought now. Now coming to the next, obligation of the person making arrest, to inform about arrest to a relatives or friend. This we have already gone through. So this is simply, kind of concurrence with the earlier section that has been brought it and made it very clear. Now power to seize offensive weapons immediately. That is the now new thing. Seizure of the weapons are very much important. Immediate. See, the word is immediate. That is where we need to understand, and which was lacking in the 52 CRPC. Now going to the next, that is the examination of the accused by medical practitioner at the request of police officer. Now there is, this one more substitution, that is 51.1. What is the substituted word? They have said that registered medical practitioner aligned. They have like an aligned. Earlier it was not aligned. Now it has been aligned as per the National Medical Register or the State Medical Register. One more thing. Another major deviation, what it mentioned in the 51.1 is that request can be made by any police officer without rank. So earlier there was a rank. Now that rank officer was, used to make the request. Without that, no one can make. Now that particular hurdle has been done away. So now any police personnel or officer. Okay. Now examination of the person accused of rape by medical practitioner. So registered medical practitioner is now modified. So what is the procedure? You try to find out there is a registered medical practitioner available in the government hospitals. Suppose if not, then what? Then the registered medical practitioner of others who has registered themselves with the act. Now, to them, the police officer can, take them, but they has to make it in a writing saying that this is what is the situation. And because of that, registered RMP was not available in the government hospital. So we have taken to the, private practicing registered medical practitioner. This is what they are there. And one more again difference is there. As per 51, there is a 52 also says that any rank officer, not specific rank officer. That is the one more. Another important change, what as per 53.1, it says that examination of the arrested person by medical officer. Now, if the registered medical practitioner is of the opinion that one or more examination of the arrested female is necessary, it can be taken. No problem in that. So there can be second medical, examination can also be taken. So if there is any doubt, any kind of dispute is there, that can be easily overcome. Earlier it was not there. Earlier it was not there. So now this way out has been given for the betterment and to resolve the dispute and to bring a solid evidence at the very primary level, at the very initial stage. So if initial evidences are very much clear, intact, and as per law, if they are being gathered and arranged and secured and safely produced, then I think speedy trial can take immediately next course of its logical action. Then if we go to the next, that is the person arrested not to be detained more than 24 hours. Now there is one more deviation. What this is that from the place of arrest, they has to present within 24 hours. But suppose if not, then what? So what this is that no need to go, but you need to immediately produce is whether having jurisdiction or not. It means that whether jurisdiction magistrate or not, doesn't matter. You produce him as early as possible. And then from there, it can be transferred to the regular one who is having jurisdiction to entertain that particular, as per the jurisdiction, then go ahead with that. Now let's go to the next one, that is the 63 to 71. It talks about the process to compel appearance, summons and all those things. So form of summons. Now here is the beauty. Earlier you used to say that paper, stamp, seal, then the bailiff will go serve the summon. No. Now if you are having electronic mode, email ID, it can be sent on that also. So that is what, say, issue summon in a encrypted or any other form of electronic communication and shall bear the image of the seal of the court or digital signature. And IQAC says that if the copy is being generated and if it is cross-verified with the another 64 encrypted technology, then it is a proof. Like how you are getting that. आपको इंजीनियरिंग वाले बच्चों को पता होगा कि स्टेट कमीशन के पास वो क्रिमिनल एंड नॉन क्रिमिनल का जो आता है तो उसमें एक ग्रीन टिक करके आता है सिग्नेचर पे, मतलब क्या, इट्स वेरीफाइड, इट्स जेन्युइन एंड इट डज हैव दैट बारकोड. आप कभी वो बारकोड डालोगे और वो बारकोड जैसे आप स्कैन करोगे तो वो आपको सीधा ओरिजिनल लिंक पर लेके जाता है जहां से वो गवर्नमेंट का बताता है हाँ ये ओरिजिनल है, वेरीफाइड है, कमीशन ने इश्यू किया. इसी तरीके से यहाँ पर भी कोर्ट का जैसे आप उसको स्कैन करोगे तो वो लॉजिकली, बिकॉज आई वाज गोइंग थ्रू विद द कमेंट्स, सो आई जस्ट वांट टू टेल इट to the students who are not very much clear about this, how that misuse genuinity and whether it has been really original or is it been fabricated or someone has just playing prank on me. So all those problems can be easily taken care in these particular aspects. You need to simply be cautious, like you use the website, how website is genuine or not, you need to use HTTPS. If S is not there, the website is not genuine, as simple as that. So it's like that. Here also they have come out. So we have taken care of that here also. Now someone how to serve, पहले मैंने बोला ना कि जाके देना है, करना है, चिपकाना, ये कोई जरूरत नहीं है. अगर अभी आपने ऑनलाइन भी भेजा है और अगर वो सर्व्ड हो गया है और अगर कोर्ट को ये सेटिस्फेक्शन है कि हाँ मेल गया, इनबॉक्स में सेंड की डिलीवरी दिख रही है, तुमने खोला नहीं खोला, दैट डजंट मैटर. पर अगर वो मेल सक्सेसफुली सेंड हो गया है और प्रोसीजर फॉलो हो चुकी है तो इट विल बी कंसिडर दैट इट हैज बीन लीगली, समन हैज बीन सर्व्ड थ्रू इलेक्ट्रॉनिक मेल. Okay, that is what is very important, because rules and regulation are not that much problem. It can be simply correlated with the Information Technology Act there, like how we do here for the banking law, Banking Evidence Book Entry Act. This is how we simply get that entries are there and it has been sent, it is reflected, done, matter closed. So SPSS, SSP and your server are also there to help you. So there is no problem in that. Now let's go to the next, another important 65. अगर किसी कॉर्पोरेट कंपनी को सर्व करना है समन तो क्या करोगे? नो प्रॉब्लम. अर्लियर दिस क्लैरिटी वाज नॉट देयर. अभी उन्होंने देखो क्या बोला है, Service of someone on a firm or other associated individual may be affected by serving on any partner association by letter sent to the registered postal of such partner where service shall be deemed to have been affected when the letter would arrive in ordinary course of course. तो जो कॉन्ट्रैक्ट लॉ का कॉन्सेप्ट था आपका वाला, वो कॉन्सेप्ट अभी सीधा कोरिलेट कर दिया है यहाँ पे इन्होंने 63 as far as that whether it has been received or not or got what are hell all those problem we used to fight because belief find it difficult like क्या प्रॉब्लम है जज सब 4 बार बोल रहे बंदा यहाँ पे नाटक कर रहा है मिल नहीं रहा है मैं 4 बार धक्का खा के आ गया अब यहाँ पे ये है वो है तो ये सब इश्यूज को अभी बहुत ज्यादा तरीके से स्ट्रीमलाइन कर दिया गया है नाउ द सी अनदर इंपॉर्टेंट क्योंकि यहाँ पे फिर डिस्प्यूट हो सकता है सेक्शन 70 सेज व्हाट प्रूफ ऑफ द सर्विस इन सच केसेस एंड व्हेन सर्विंग ऑफिसर नॉट प्रेजेंट तो देखो ऑल समन सर्व थ्रू इलेक्ट्रॉनिक कम्युनिकेशन अंडर 64 to 71 both inclusive shall be considered as duly served shall be considered as a duly served and see how it can be proved like you say ना देखो भाई इन्होंने चार्ट तो किया था मेरे पास स्क्रीनशॉट है अब क्या करोगे क्योंकि स्क्रीनशॉट को तो कुछ चेंज नहीं होता इट ऑलवेज कम्स विद द हैशटैग दैट इज दैट डबल लाइन एंड क्रॉस लाइन ऑल दोस थिंग्स और उसमें देखो क्या हो रहा है कि
you have left to section 66 you are not discussing about section 66 and in the slide also you are not showing section 66 what is your opinion about section 66
I request everyone to mute their mics. Yes, sir. Please continue.
Yeah, I think there was some sir was asking about 60
66 why you are not mentioned section 66
service when person summoned cannot be found.
So this electronic things that the digital system would have been so added everywhere. So that is the only one thing which we are taking care.
Sir, that
again and again
yeah,
the sentence is there. The sentence is reducing and sentence is enhancing. All those things are so one thing everywhere repeatedly we are doing it wherever the 5,000 is there, 5 lakhs. That I am not going to go around that. What I would like to say, the service of someone once this will be sending so electronically or whatever it may be. So reducing the button in one side and whether it is receiving or not, so they are not taking it in certain circumstances. So substituted method of services are there, personal service is there, then electronic media also there.
Okay,
so these circumstances, what I would like to ask you, so this present new system of law, this section 66, so is there in 1973 Act also. Even prior to that in 1898 Act also the same thing. Why the people are not have been concentrating on this aspect? So, what is your opinion on that?
Yes, sir. So with your, I think if I heard you said that suppose if it is not been served, means there are two questions basically. One, you said that if the person summoned cannot be found, so what would happen even if suppose this has been done through electronic manner? And second, you are asking that the procedure when service cannot be effected as before provided. Am I correct? Am I correct, sir? So
yes.
These are been already been answered in section 66 and 67. So just for our understanding, I take your permission to read and then I will explain. So things are been very crystal clear. Jurisprudential aspects are also clear. Only thing is that
our I am not, sir. I don't want to discuss jurisprudence and other aspects. So jurisprudence will not be wherever the legislative sanction is there. So that is very essential for practicing advocates. So
yes, sir.
My question is specifically, I will read that section. Service when person summoned cannot be found. Where the person summoned cannot, by the exercise of due diligence, be found, the summons may be served by leaving one of the duplicate for him with some adult member of his family residing with him, and the person with whom the summons is so left shall, if so required by the serving officer, sign a receipt therefore on the back of the other duplicate. So, this section, what is your opinion on this section? Why you have not actually? So, the people who have in the 1898 Act or 73 Act or in this 24 Act, wherever, or even you have submitted the slides in the entire scenario of each and every process. Here also section 66, that means what is your opinion on that after reading those sentences, including explanation.
Okay, so what happens here, sir, that there is an extreme situation that has been considered. Extreme situation is that we have served, now there is no response from the person. So court has considered that, okay, we have sent electronic also, but still on that date time and that particular procedure has not been followed. So as a backup, if you see, it's very clearly mentioned here is that service when person summoned cannot be found. So the word cannot be found is, considered as an extreme level.
And I am not expecting what I would like to, so cannot be found at home. So who are eligible to take some?
His relatives.
Huh?
See, here is a combination of two things, sir. One is
Here the
electronic.
wording, here the essential word, extreme, how you are using the adjectives. Here you have to see that, so adult member of his family. Suppose if I have 3 girl children and wife and mother, I don't have no other person, or you don't want to consider them as an entity, and a servant is not a family member. So where the woman will go for, and they are not eligible for receiving the summon.
No,
So
but
they are
I
not,
think, but
even
sir, my
declaring that,
my humble,
same
my
professors who are giving lectures with relating to various things, women empowerment, women has performed that, and reservation policies necessary, that is each and everything. This section so specifically insulting the women.
I think, sir, with my due respect to you, we should, think in a logical manner, in a process where, see, it's the, if you see this particular language, it's a gender neutral language, and considering your concern related to the women's and all other aspects, if you see what they say is that, by leaving one of the duplicates for him with some adult members of his family. And adult means there is no explanation required. Now coming to the next, whether it is woman or male, also now comes some adult member of his family. I think that the wording itself is so crystal clear that we should not unnecessarily bring gender biasness, or what would happen and what will be happening and what. So here we have already considered, means the legislature has already considered. Now coming to the next point, that they says that this is a kind of backup, which section already clearly says when this section will come into play, sir. That is the first question we need to ask ourselves, that when this section will come into the picture, when all other existing manner procedure established by law has not been appropriately deserved to be resolved or been fulfilled, and still person is at large from the judicial hands, then this particular section comes into the picture, and then it start taking its course of action. And I think this is what is been expected here. And that's what I told you, that when we go through slowly, and once the matter started coming, then we need to see how the court is going to reply to that, because our mindset is already as per the old notion. I appreciate with due respect, I appreciate the concern you have raised, but with my little opinion and with my little word involvement in this kind of drafting, this is what we have forecasted as of now. But it is not full and final. I again admit that it is not full and final. It is the time only which will let us know that whether it has been properly executed in a proper manner, the way it has to be executed to take appropriate course. Okay, I hope I tried my best, sir, but yes, the concerns are there, I know, but this is what we have think.
Okay.
that when it will come to the picture and start, application. Because before this situation, there is no question of bringing section 66 and 67 into the picture. But there should not be, any gap to be left out. There should not be a vacuum. So how to overcome from that vacuum, or how to close those gaps where, the nascent stage or playing around thing can take place. So, and that's it, I think. Thank you. If there is a further more time, I would like to go
Yes,
ahead
Dr.
with
Rahul. Dr. Rahul, your explanation, your presentation is very nice one. But for the participants, it will be
Yeah.
really bulky because they are listening the resource person from last 2 hours.
Yes, that's why.
Okay,
That's
you
why.
can take your own time, sir. No problem.
No. Because, sir, honestly, I am having more than 150 slides with me.
Yeah,
and
yeah.
and this is my 15th session on the criminal
Oh,
law.
very good,
And
very nice.
due to the paucity, I was not, in the kind of decision that I should take all the students to whole thing. Because
Correct.
if you bring lot of bombarding, nothing
Yeah.
will go into their mind. Rather than, I thought that let be it, piecemeal manner, small portion.
Correct.
Let's be, crystal clear on those small portion. And then once we are clear, then we'll move to the next section, sort of thing. The another important aspect, that zero FIR is also there, which is very interesting. But
Correct.
due to the
No,
paucity of
Dasai Mahendraji Nide, Honorable Chairman and Chairperson of this program, is keenly listening you from last 1 hour. Yeah.
Yes, महेंद्र सर, आमचे प्रेरणास्थान आहे ते. सर, काय चुकलं असेल तर माफी मागतो तुमच्याकडे.
No problem, sir. No problem. Dr. Reddy, sir, Principal of SS Manera Law College and ex-Chief Faculty of Law, was asking you the question.
Yes, I
Yeah.
know. I know
Yeah.
him. I know
Yeah.
him.
And after all, his question and your answer is benefiting the participants. Yeah.
Yes, sir. So, sir,
Nice, sir.
thank you so much
Yeah.
for grilling
Nice,
me also, and I hope I tried my best to answer.
Yeah. Please
Because,
continue. Please continue,
senior.
Rahul.
So, should I
Yes.
continue?
Yes, sir. Yeah, Dr. Rahul, continue.
Okay, so now I am just shifting to the another part of our discussion, but I will be briefly going through. I will not take much more time. Now the another thing. So here is, see this, what additional power for attachment and forfeiture of the property is very much very clear. So what they say, see here, you need to understand, found to be proceeds of crime is important. So now under that, property, immovable property can also be forfeited. So this is the another aspect that has been brought in here. Now when you go to the, just 1 minute, when you go to the next, now see here, seizure of immovable property. Now this also been brought in the new concept of 107. Now this is, as usual, no need to go there. This is very important, zero FIR. Now what happens here, that police to register FIR where the information is got, whether orally. Now see the important aspect, orally or through electronic communication. Now nowadays you are seeing that, suppose young brigade, आपको तो पता है, गाड़ी मतलब उनको लगता है मैं माइकल शुमाकर बन गया, भूम करके जाते हैं, फिर पुलिस को उनका इंस्टा पे वीडियो मिलता है, फिर पुलिस पकड़ता है, फिर बोलता है अरे मैंने तो कुछ किया नहीं, फिर उनको दिखाते हैं बेटा तूने ये किया हुआ है. So this is how is very important, and zero FIR is the immediate help. So here you need to understand, 173 is now giving out way here कि भाई प्रोसीजर होती रहेगी, फॉलो करेंगे हम, पर अभी इमीडिएट मेरे सामने ये हुआ है, तो मेरी जिम्मेदारी पुलिस की कि मैं इसको फटाफट zero FIR करूं, कस्टडी में लूं एज पर लॉ. अगर इफ इट इज कॉग्निजेबल, नॉन कॉग्निजेबल, बेलेबल, नॉन बेलेबल, फटाफट करो, डॉक्यूमेंट तैयार करो. वो करने के बाद फिर कंसर्न जिसके पास वो जुरिस्डिक्शन है उस कोर्ट में जाके उसको प्रेजेंट करवाओ, और फिर उस पुलिस स्टेशन को उसको हैंड ओवर कराओ. सो दिस इज ऑल्सो इम्पोर्टेंट. अभी देख इसमें क्या है कि टाइमलाइन, प्रिलिमिनरी इंक्वायरी एंड इन्वेस्टिगेशन. अब ये एक इम्पोर्टेंट है. ये कॉन्सेप्ट कहाँ से ली है? ये कॉन्सेप्ट हमने ली है कॉर्पोरेट लॉ से, स्पेशली NTL, नेशनल कंपनी लॉ ट्राइब्यूनल एंड सेबी का. उसमें क्या लिखा हुआ है कि 45 डेज, 60 डेज, 90 डेज पक्का करना है. कंपनी लॉ 2030 में जो लिखा हुआ है उसमें भी बहुत क्लियर किया गया है कि इवन इफ इट इज गोइंग फॉर द इंसॉल्वेंसी, बैंकरप्सी, 280 दिन में खत्म ही करना है. देयर इज नो फर्दर डिले. और अगर करना है तो फिर जज के ऊपर आ जाता है। भाई जज को बोलना पड़ता है रिटर्न में लिख एंड में कि ड्यू टू दिस रीजन आई वॉज नॉट एबल टू कंप्लीट विद इन दिस डे। तो यहाँ पे 14 दिन के अंदर मैजिस्ट्रेट टू डिसाइड वेदर टू टेक कॉग्निजेंस ऑफ द चार्ज शीट विद इन अ पीरियड ऑफ 14 days. So now the compulsion is on the judicial officers as well. अब जब हम आगे चलेंगे तो अभी इसमें देखिए क्या है कि 173.3 में क्या बोला गया है कि ऑफेंस इज पनिशेबल फॉर 3 years और मोर बट लेस देन 7. तो ऑफिसर इन चार्ज नाउ में विद द prior permission of the DSP proceed to conduct a preliminary inquiry within 14 days to ascertain if there exists a prima facie case and proceed with the investigation whether there exists one. सी इसमें भी मिसयूज होता था, अब इसको चैनलाइज किया गया है और इंटरनल एक तरीके से किया गया। अब आपको एक अगर एक रिसेंट एग्जांपल दूं, अभी एक बिहार में या झारखंड में हुआ, accused was on the bail. He supposed to police supposed to jail authority supposed to take him to the hospital. उसको छोड़ दिया, वो अपनी बीबी के साथ होटल में था और उसके दोनों बच्चों को जो केयर टेकर था जेल का, जो उसको सपोज टू टेक टू द हॉस्पिटल, वो उनको मॉल में घुमा रहा था। और जैसे ये फोटो ये वीडियो जब वायरल हुआ तो भाई साहब गए ना हाईएस्ट अथॉरिटी ऑफ द स्टेट पुलिस, फिर वहां से ऑर्डर आया, उसको इमीडिएट सस्पेंड किया और बोला कि सभी को अभी डायरेक्शन इशू किया गया कि इस तरीके का मिसयूज नहीं होना चाहिए। सो दैट इज द वन मोर एरिया देयर एंड हियर इज आल्सो वन मोर एरिया which we can correlate over here. अब now यहाँ पे थोड़ा सा contradiction है. If you see that the contradict the direction of the Supreme Court in the Lalita Kumari versus Government of Uttar Pradesh, which maintained that the police to record information of a cognizable offence as FIR and investigate the offence regardless of what the police felt about the credibility of the information. ये पहले बोला गया था। अब देखो नए jurisprudence के हिसाब से क्या होगा कि यहाँ पे थोड़ा सा भी चेंजेस है। तो नाउ लेट्स सी दैट देयर शुड बी अ केस दैट हैज टू बी रीच्ड टू द सुप्रीम कोर्ट एंड देन बेस्ड ऑन द न्यू इंटरप्रिटेशन ऑफ द सेक्शंस, नाउ दिस पर्टिकुलर केस लॉ वर्डिक्ट विल आल्सो बी चैलेंज्ड एंड इट हैज टू बी चैलेंज्ड, अदरवाइज इट विल क्रिएट अ प्रॉब्लम इन दिस वन। सो देखो यहाँ पे क्या किया गया, 173(4) क्या बोलते हैं, विच प्रोवाइड्स दैट द कंप्लेनेंट मे फाइल एन एप्लीकेशन टू द मैजिस्ट्रेट टू रजिस्टर एन एफआईआर ओनली इफ the superintendent SP does not investigate the case or direct a subordinate police officer to investigate as per this. So now here citizens are being empowered. पहले होता था ना भाई, कर रहा है नहीं कर रहा है, घुमा देते थे चला देते थे, अब ऐसा नहीं होगा। और कोर्ट भी बोलता था भाई जब तक पुलिस नहीं लेगा हम क्या करेंगे, तो उसमें एक टाइम चला जाता था। तो नाउ दिस हैज बीन कवर्ड अप इन दिस वन। सो अगेन नॉट मनी लॉन्ड्रिंग का भी एक एस्पेक्ट इसमें आ गया है, तो दैट इज आल्सो देयर, this is also there. Again 0 FIR, I think yes we are going up. Okay, I'm going down, yes down. Okay, yes, this is also very much important, that is the police officer on completion of investigation report has to be submitted to the magistrate within 90 days. पहले ये मिसिंग था। पुलिस क्या करते थे, पुलिस बोलता था भाई मैं कर रहे सर, चल रहा है, फिर पीछे से किसी ने उसको एक पैकेट थमा दिया तो और बोल रहा है चल रहा है, मतलब 90 दिन बैठ गया और 90 दिन बैठ जाएगा और एक साल हो जाता था। तो अभी ऐसा नहीं चलेगा। So 90 days is very much there. So there is a time bound process. So police has to submit it to the court और फिर उसके बाद कोर्ट को कॉग्निजेंस होगा, तो फिर कोर्ट बोलेगा कि इतने दिन आप क्या कर रहे, ठीक है ना। सो दिस इज अनदर वेरी इंपॉर्टेंट। सैंक्शन फॉर प्रोसिक्यूशन अनदर वेरी मच इंपॉर्टेंट 218। तो क्या कहता है 218, नाउ प्रोवाइड दैट द गवर्नमेंट शैल टेक द डिसीजन ऑफ वेदर टू ग्रांट सैंक्शन फॉर प्रोसिक्यूशन ऑफ जज और पब्लिक सर्वेंट विद इन 120। पहले क्या होता था, बैठ जाते थे from the date of the receipt of the request for sanction, and if it fails to do so the sanction shall be deemed to have been accorded. अब ये जो प्रोविजन है, ये प्रोविजन कहां से ली है, इसका भी आपको इसका एक लॉजिक बता देता हूं। ये लॉजिक लिया गया है सेबी एक्ट, सिक्योरिटी एक्सचेंज बोर्ड ऑफ इंडिया 1992 में लिया गया है, जिसमें यह बोला गया है कि अगर किसी कंसर्न रेगुलेटर ने विद इन 45 डेज अगर आपके एनसीएलटी को या सेबी सैट को, सिक्योरिटी एपलेट ट्रिब्यूनल को अगर इंफॉर्मेशन नहीं देते तो हम ये मानेंगे कि गवर्नमेंट को कोई दिक्कत नहीं है, गवर्नमेंट की इसमें हाँ है। तो अभी यही लॉजिक जो फाइनेंशियल एंड कॉर्पोरेट लॉ का लॉजिक लिया था, अब वो लॉजिक यहाँ पे सीधा प्रोसिक्यूशन के लिए भी लेकर आ गए हैं। So government cannot now escape simply sitting idly on the request and not giving any response. तो ये भी एक अभी गवर्नमेंट के ऊपर भी है इसमें. Committal to the sessions court, ये अगेन एक है कि BNS stipulates a time period of 90 days to commit the offense to the sessions court, which may be extended for a period not exceeding 180 days for the reasons to be recorded in writing. जैसे मैंने आपको बोला था, ये कॉन्सेप्ट भी कहाँ से ली है? ये कॉन्सेप्ट भी हमने यही से ली हुई है, आपके सेबी, फिर आपका कंपनी लॉ, और फिर आपका रेवेन्यू लॉ, फिर आपका जो सरफेसी एक्ट है, फिर आपका जो आईबीसी है, उसी में से हमने ये लिया है कि देयर शुड बी, इफ दिस अदर fraction of law, if they can work out with the time bound manner, what is the problem with the criminal cases? And criminal cases are more nature, because their humans are involved. Here financial aspects are involved. If financial aspects are being taken care of so much gravity, then the same can be taken when the humans are in stake, or the problems related to the human, their bodies are at a serious jeopardy, then why can't here? So here is again a welcoming stage, very much appreciated, and we want it to be there. Because one more thing we have seen, आपने अगर देखा होगा कुछ जजेस उनके पूरे लाइफ स्पैन में कितने डिसीजन दिए हुए हैं, ये भी आपको पता होगा. तो जनरली there are certain fractions of judicial officers who do not do proper. तो आपको ये भी पता होगा. तो अभी आपको मैं बता दूं कि अभी मिनिमम 1 महीने में मिनिमम 30 केसेस का निपटारा करना कंपल्शन हो गया है, क्योंकि आई एम हैविंग लॉट ऑफ जजेस आल्सो एज माय LLM student and as well as my PhD student. So I get all this input from here and there, from various nook and corner of the practicing domain as well as academic domain. तो अभी वो मुझे बोलते हैं कि सर हमारा जो है ना फिर बुक में चला जाएगा, हमारा प्रिंसिपल एडमिनिस्ट्रेटिव जज फिर मीटिंग में हमें ये झाड़ेगा कि भाई तूने 45 दिन में तूने 30 केस भी नहीं दी, 20 केस भी नहीं दी, क्या कर रहे हो आप क्यों ज्यादा उनको नेक्स्ट डेट देते हो? नहीं दे रहे तो उसको बोल 1 2 तीसरे में खत्म करो. दिस हैज बिकम द नोशन. So this is again welcoming here. Now framing of charges, trial and judgment, again very much important. There is a timeline of 60 days, for the session judge for the date of the first hearing to frame in writing a charge against the accused. Very much important. So see, that's what I use, that सबका साथ, सबका प्रयास, सबका विकास, और speedy trial, speedy delivery of justice कैसे होगा? तो ये टाइम बाउंड जब तक नहीं करोगे, और आपने अगर देखा होगा इसमें उन्होंने लिखा है कि कुछ स्पेसिफिक जगह पर ही उन्होंने बोला है कि इफ यू आर नॉट एबल टू डू देन गिव इट इन राइटिंग रीजन एंड देन यू कैन एक्सटेंड फॉर हाउ मेनी डेज. कुछ सेक्शन में दे आर नॉट मेंशन इट, सो मींस इट्स बाउंडिंग, इट्स ऑब्लिगेशन. You have to do it means you have to do it. There is no further yes or no or excuses, something like that. Now if you see here, especially in 258.1, it says that after hearing arguments and point of law, the judge shall give a judgment within 30 days from the completion of the argument, which may for specific reason. How long? Just 45 days. More extension is just 45 days. अब इसका कोरिलेशन IBC का है, इंसॉल्वेंसी एंड बैंक्रप्सी लॉ जो है हमारा 2016 का, इट्स कोरिलेट. सो सी देयर इज सम नेचुरल जस्टिस, difficulty in administration of justice, difficulty of the police forces, enforcement agency, and difficulty of the courts. So now keeping in mind all these stakeholders, now the time limit has been framed accordingly, and 45 days are, I think, more than enough. If in logical manner, if we see, it is very much there. And now one more thing is there in 392, that the court shall upload a copy of the judgment on its portal within 7 days from the date of the judgment. This is not there. So this is also again welcoming, things that is very much. And this is the part of e-court, which is now in the 3rd phase. And if you ask in the Gujarat, almost all the district courts are now made e-courts, and a lot of progress has been taken care. There is little bit so place that is going on in the Maharashtra, but Delhi, Andhra, Tamil Nadu, Gujarat, they are on the forefront, and there is very good progress that is going on as far as e-courts and hearings are concerned. So it's a welcoming. Maharashtra is little bit lagging, so we need to push it with the concerned authorities that how things can be done there in that manner. Discharge, very much important. 262 says that the time limit to accuse is what? Period of 60 days from the date of supply of copies of the documents. Very much important. Then 247, what it says? If the magistrate considers, very much important, accusations as groundless, he shall, after recording reasons in writing, release the accused, and such release shall have the effect of discharge. So, how to lessen the burden on the court? Very much is very, there, and which is being taken care of properly. Summary trial, yes. Now provide magistrate may, after giving accused reasonable opportunity of being for reasons to be recorded in writing, trial summary way, all or any of the offense not punishable with the death, imprisonment for life or exceeding 3 years, and that no appeal shall lie against any such decision of the magistrate. Now is the key, how to reduce the burden of the higher judiciary. So here, two sides of the things you need to see: speedy trial plus final. No further argument. Even no need to go to the Supreme Court also. If the initial stage, the session court is saying something, that is full and final. This is what very much required. Now it has been there. So now advocates should be very much cautious. There is a caution to the fraternity, as well as there is, so there are good side, there is bad side also. So be careful in the summary trial. If it is been dismissed, then there is no further way of appeal or something like that. Now, signature and finger imprisonment very much was dicey, but now it has been made very clear, aligned with the IT Act. That was the crux. And forensic science now, because I have already published one of my paper where I said that the Law Commission has already brought one bill, forensics and DNA laboratories, and how the criminal proceedings should accommodate the findings of those particular FSL laboratories, as a primary evidence, not secondary. So I was also, I'm working on that, and we are pushing, saying that this 346 or certain technological aspect, let's say that the crime scene is so bad, where the evidences are so much diluted, where without help of technology you cannot even ascertain what is the next chain of evidence, or what is the way the accused is at large from the enforcement agency's hand. Now here is the important things, that earlier they used to say that it can be considered as a secondary, and that too again discretion of the judge. Now that notion has been completely reversed now. Only thing what we are expecting now, that the Home Ministry should come immediately, the Law Commission bill, which we already had there, and lot of discussion took place, and because of these sections are involved, which talks about the involvement of technology, forensic laboratories establishment, and the reports, because there are 4 things: handling, packaging, transportation, and the authenticity in the forensics reports. These are the major 4 concerns. If we are having proper regulation, those are being followed there, then why we should consider it as a secondary evidence? Let's straight away bring it to the first evidence category, and let the matter be closed, purely relying on scientific evidence. Because I had an opportunity to visit to the Switzerland and Norway and USA, so I was one of the member in the discussion group of their criminal law proceedings, how technology has been involved in their proceedings, and how court of law takes cognizance, and how it is beyond doubt has to be accepted, which was certainly lacking in Indian context. So we got input from there, and we tried to arrange it in the Indian context, not directly copy and pasting, but wherever relevant, keeping in mind the existing IT infrastructure rules and regulation in mind, how the AI or technology or forensic science, can be helped to the administration of criminal justice, not the criminal justice, the administration. That is what I'm again insisting. Now the notion is administration of criminal justice and not the criminal justice administration. So this is, the buzzword. Now you will be able to see. I again got one more yellow line. Thank you so much, guys. I know you are boring. So, sir, should I stop here? Because now I think it might be heavy for student. Bairam sir, Sabnis sir, are you there?
Yes, sir. It was good session, sir.
Yeah, there are a lot of things, but then I must stop myself. Otherwise, so I think thank you so much to our Mahindra Nilay sirji, माझे गुरुवर्य बहिराम सर, सबनीस सर, ही ऑपॉर्च्युनिटी देण्याबद्दल. अँड थँक्यू सो मच. कोणाला काही क्वेश्चन असेल तर विचारू शकता. Otherwise, from my side, there are a lot of things to be said, but all cannot be covered. So I'm taking
Time
your
constraint.
permission. Yes, time constraint. I have to see because I am a very bad speaker. I did not confine myself with the given limited time. So
No,
I
sir,
again
it was very good, sir.
apologize for myself to cross my given timeline. But again, sometimes it's the need of the hour, so we speak.
Thank you.
That's it.
Thank you, sir. Sir, I must appreciate your one.
Hello. Am I audible? I'm not able to hear you. Hello.
Yes, sir.
Yes, I
Sir,
think there was some disturbance. Yeah, you were saying something, please.
Sir. Hello.
Yeah, now I'm able to hear you. Please proceed.
Sir, I must appreciate your line, the one line which you used, that no law is perfect. It is always evolving. That is very true, sir.
See, let me tell you from my 14 years of experience, I'm expert in corporate law. Every 3 months, we used to get lot of amendments from the SEBI, from the RBI, from the practice that ICDA and all those things that we need to keep update ourselves. Let me tell you.
True, sir.
And this aspect was very much lacking in the criminal and the civil side, because they were not keeping pace with the 21st century. As I always tell my students that, see, you need to be three-way lawyer. What? Smart managerial lawyer, techno-savvy lawyer, and critical thinking lawyer. So critical thinking is there. What
Yes.
about smart managerial skill, and what about techno-savvy lawyer?
Sir. Yes.
Because these two areas, which are very much heart and soul of whole general public at large, civil and criminal, they are not keeping pace with. Then what is the logic?
Yes, sir.
That's
True,
what
sir.
I think.
True, sir. Sir, thank you, sir, for your exceptional, insightful, informative, and knowledgeable session, sir. We appreciate your for sharing your experience, your expertise in Bharatiya Nagrik Suraksha Sanhita, sir. So thank you for guiding us through specific sections.
Thank you so much.
So it is a proud moment for us, sir. You are our alumni, sir. So thank you so much for that.
Thank you. हे आम्ही बहिराम सरांच्या समोर आम्ही काहीच बोलत नाही. ते सांगतील तेच आमच्यासाठी फुल अँड फायनल. आम्ही काहीच बोलत नाही. आमचे गुरुवर्य येते. त्यांनी आदेश द्यावा.
Even I am student.
Rahul,
त्यांनी
today you have fully fed up us. Today you have fully fed up us by delivering a fantastic lecture on BNSS. Yeah.
थँक यू. ही तुमची कृपा. आम्ही काही शिकलो,
Correct.
आम्ही हीच माझी गुरुदक्षिणा आहे तुम्हाला. मी येईल तेव्हा भेटायला येईल, पण I always feel that when my guru, my mentor is there, we should make them proud.
Yes, sir,
तुम्ही
yes,
आम्हाला
sir,
हे
yes, sir.
शिकवलं.
Welcome, Dr. Rahul. Yeah.
Thank you so much, sir. Thank you.
Sir, now I would like to request the honorable chairperson of this of today's program, Babasaheb Mahendraji Nile. I hope he's online.
Akash sir, before that, Dr. Reddy sir is there? Dr. Reddy sir, please request Dr. Reddy sir to share his views. If he's
Okay. Dr. Reddy sir, are you there? Yes, sir.
yeah.
I
Yes, sir.
request respected Dr. Reddy sir, Principal Maniar Law College, to share his thoughts on today's work, sir.
Honorable Chairman of Babasaheb Ambedkar College, Delhi, and Dhule sir, and the Honorable Principal and the Associate Dean of Law Faculty,
Reddy sir, your voice is not clear.
Principal of
You are not audible.
Law College.
Sir, you can keep your microphone near to your mouth, so
Mouth, yeah. Reddy sir.
it can be louder, sir.
Now, are you getting
Yeah.
somewhat better?
Somewhat
No,
better, sir.
not sir, not yet.
Okay.
You keep your mic nearest to your mouth, sir, so that it will increase the voice.
Yes.
I think it's a internet glitch. It's because of low internet bandwidth.
So internet.
Now,
Yeah. Please try to speak, sir, so that we will experience.
Honorable President of Dr. Babasaheb Ambedkar Management Council, Mahendra Dhule sir, or respected Principal Dr. Bairam sir, Associate Dean of Law Faculty, North Maharashtra University, and Dr. Dhule sir, Principal at TVS Law College, US Chairman, and respected resource persons participated. They have created time for spending with us for our university. So the meritorious lectures they have delivered, in spite of that, we will be having some of the things here, where some may be left over, these things. When we call it as, so when the law is an instrument of social change, law is an instrument of social order. In such and such circumstances, techno-legal, medical-legal, political-legal, like that changes will come, which we have already gone through in the entire scenario, how the changes will go on under law and social transformation. Such and such circumstances, we need not to say. So the doctrine of ratio descendi itself says that if any principle, any matter came before the judge should wait for law or judge has to decide. General meaning we are taking that what is the judicial activism main principle of the case. So like that we are taking that. The question is, nothing is there relating to law. Such a social problem comes before the judge. Whether he has to wait for law or not, that will be the question. Such and such circumstances, these social changes will create. The judge should not wait for law, he has to decide this is the available sources. That means that may be the political related or social related, whatever it may be, and he should give the conclusion. So the main principle which he has formulated can be considered as ratio tested. In such a manner, the rest of the principles are arbitrary. Now the changes have been made after long period, so after 1973. So whatever may be the changes are there due to technology, due to other angles, because artificial intelligence is also coming over in present days. In such circumstances, the transformation is necessary. The social ordering is necessary for making the laws performing. But only thing is, powers shall not be so arbitrary. Whoever may be, that may be related to the executive organ or the legislative aspects or political influences or judicial system. So the number of cases which have been overburdened, so we should try to see enhancement of each and every executive level, whole of executive, whole of judiciary, each and everything for getting more the intention of the legislature relating to these changes is justice system has to be provided instead of punishment system. Yeah, earlier punishment system was there. Now we are trying for getting justice. For that purpose, so immediately after that, whether the climate, so whatever may be telling not positive, even in such and such circumstances, Honorable Principal Dr. Bairam and his faculty members have taken initiation for doing this workshop. So through several resource persons, the resource persons also they have exemplarily, though they are alumni of your institution and so within our state here. So they have shown their meritorious presentations. But some of the things which we may be being a senior, so I may be interacting for them because they will be well strengthened, more strengthened. For that purpose only we are doing it, not otherwise. So anyway, I am thankful to Honorable Chairman of the Management Council and the Principal and the entire team of Dr. Babasaheb Ambedkar Memorial Law College faculty members. Thank you very much.
Thank you so much, sir. Thank you for your wonderful remarks. Now I request the chairperson of today's program, Babasaheb Mahendraji Nile, to give his concluding remarks.
Okay, thank you. As we all know that today is a national virtual workshop on new criminal laws organized by our IQAC team of Dr. Babasaheb Ambedkar Memorial Law College. And there are many resource persons, 2 or 3 are there. One of them is Mr. Dr. Reddy sir, Maniyar Law College principal, and Dr. Rahul Nikam, who is from Marwadi University of Rajkot, Gujarat, and Professor Harshada Rajput from Mumbai VES College of Law, and Dr. Anand Deshmukh sir, who is a professor and head of the department, Dr. Babasaheb Ambedkar University, and our college participant Dr. Bhivaya Bahiram sir, and other resource persons. Good morning to you all and welcome in our college, in our virtual workshop. From your discussion, actually I was late to attend this workshop. There are some points which you explain, and the new laws are formed by government, which are just we know we were knowing previously. IPC 1860 Act has been converted into Bharatiya Nyaya Sanhita 2023, and there are some major changes in these 3 laws. Bharatiya Nyaya Sanhita, which is in short form BNS, Bharatiya Nagrik Sanhita, which is BNSS, and Bharatiya Sakshya Adhiniyam, BSA. Of these 3 topics, every resource persons explained very well, and I am happy that some of these persons who are now in good post in various university or law colleges all over the Maharashtra and India, they are much capable of their knowledge, and because of them, this workshop which was arranged today, has been successful to elaborate the new laws. From your speeches, I came to know that the power of police has been too much in previous IPC section, Indian Penal Code, which has been reduced, I think. According to your speech, I came to know that means everyone, all participants who are attending this workshop are well known to this, your facts you explain about that. Means the police has been empowered, but their power has been reduced. And the time binding is there for each legal time binding has been put on for every judicial process, I think so. Means hearing and then judicial hearing, police inquiries, these are all time binding. So it's very nice for our Indian people, I think. And this will help each and every person who is related to legal formalities. It will be beneficial for our legal system, especially judges and lawyers, as time binding will reduce court cases in future, I think so. So we should welcome these new laws implemented since from 1st July of 2023. So that will be beneficial for Indian people and judiciary system, means police, judiciary and lawyers. And so ultimately, who is innocent people, for them judicial justice will be there, and for them this implementation has been done. And as Mr. Doctor, 1 minute. Mr. Rahul Nikam sir and Dr. Deshmukh, you have said that every law is not perfect. Some deficiencies will be there, some deficiencies will be sorted out. Okay. And according to development of economy or development of technology, everywhere this is happening. You just said that according to SEBI and RBI's rules to implement, they are changing their rules 6 months, 3 months later, or each and every month they are making the changes in their guidelines, so as to balance our social justice also. So each and everyone has to take part in such changes to implement these laws to get benefited our public or our people who are struggling for the justice. So time is too much more, has been much more. It has been now, I think, since 10 o'clock. I am waiting for your speeches. And you said that you are from our college. And we are very happy to know that each and every student of our college has become very eminent personality. So the college is calling you to deliver a speech for such online workshops. And I think that your progress will be always there. And in future also, our college will always call you to deliver such a speech physically or online. So that next our participants are our college students and lawyers. These laws are very important for them. And just a few days back in our college, there was some personalities from excise department and bar council of Dhule Bar Council in court. They had invited our professors to, because they had invited, they need your guidance, because laws are there. Implementation is done by judiciary and police, but lawyers are there also. They are also serving our nation to get justice for the people, and for that purpose they invited our professors, lecturers. In a few days back, Bar Council Dhule, they invited our professor to deliver speech regarding these topics, these new rules, Bharatiya Nagrik Sahita 2023, and they are in need of this guidance. So lawyers are also in need of this guidance, because the lecturers, all the lecturers all over India, not only you and our lecturers of college, but each and everyone is in need of this knowledge. What is going on? What is going to happen with these laws? It is important, and it is responsibility of each and every person, not only person, but especially professors who are in legal education, to deliver, to guide these those students who were our student and who are lawyers now. And I think sometimes judges also are in need of this guidance also, because each law is not complete in all aspects. So some amendments may be done in future if you demand. So you get united on some platform, and if there are some things which you want to recorrect or correct them, so you can form a panel for these things. आणि आपल्या धुळ्याच्या ज्या लॉ कॉलेजच्या ज्या स्टुडंट्स आहेत, ते सुद्धा मनापासून तुमचं सगळ्यांचं लेक्चर्स ऐकतायत, की आमचे स्टुडंट तुमचे ह्या लेवलपर्यंत, कोणी गुजरात युनिव्हर्सिटीला आहे, कोणी मुंबईच्या लॉ कॉलेजेसमध्ये आहेत, हे बघून ते इन्स्पायर होण्यासाठी तुम्ही जे आज इथे आलेत, त्याबद्दल माझा हे भरून आलेलं आहे असं वाटतं मला. आणि तुम्हाला एक सांगतो की आता हे सगळ्यांना असं वाटतं कायदे बदलतायत. कायदे बदलत म्हणजे संविधान बदलणे, संविधान बदलणे हा विषय नाहीये. तर हा फक्त IPC क्रिमिनल ऍक्ट्स जे आहेत त्याच्यामध्ये चेंजेस झालेले आहेत. पण बाहेर अशी चर्चा आहे की संविधान बदलाच्या ह्या धोक्यामुळे अनेकांची भीती ही पराकोटीला पोचलेली होती. तुम्हाला सांगायला मला आनंद वाटतो की डॉक्टर बाबासाहेब आंबेडकर विधी महाविद्यालय जे आंबेडकरांच्या प्रेरणेतनं उभे केलेलं आहे, आणि त्यामध्ये आपल्या इथे 650 राजे महाराजांच्या सत्ता होत्या, त्यांचे संस्थान होती, आणि जो तो आपल्या परीने लॉ कसा हँडल करायचा, कसा बनवायचा, हे त्यांच्या आणि धर्माधिष्ठित थोडंसं त्याला न्यायाला ही झालर होती. त्याच्यामुळे त्यावेळेला त्याच्यातनं आपण स्वातंत्र्य झाल्यावर जवळजवळ 305 लोकांची कॉन्स्टिट्यूशन बनवण्यासाठी जी असेंब्ली झाली लॉ असेंब्लीमध्ये, तिथे डिस्कशन मध्ये झालं तर 7 जणांनी संविधान बनवण्यासाठी आपले संविधानाचे ड्राफ्ट्स, ज्याला तुम्ही मसुदा म्हणतात, ते त्यांनी आणले होते. त्यामध्ये होते मोतीलाल नेहरू, महात्मा गांधी सुद्धा होते त्याच्यामध्ये. मेजॉरिटीत असते तर त्यांनी सुद्धा ते इम्प्लिमेंट करता आलं असतं. आणि सरदार वल्लभभाई पटेल होते त्याच्यामध्ये. अनेक लॉयर्स आणि एमिनेंट बॅरिस्टर्स होते. तुम्हाला हे सांगावंसं वाटेल मला, ह्या 7 मध्ये मुस्लिम लोकांचे सुद्धा रिप्रेझेंटेशन त्याच्यामध्ये होतं. आणि तेव्हा त्यांनी सांगितलं की आम्हाला भारतासाठी ही संविधान भारताला सांभाळण्यासाठी जे संविधान लागणार आहे, तर ते आम्ही टेबलवर आणायचा प्रयत्न करतोय, पार्लमेंटमध्ये आणायचा प्रयत्न करू, संविधान सभेमध्ये आणायचा प्रयत्न करू. पण त्या 7 जणांमध्ये अजून हिंदू महासभेचे त्यांचाही एक ड्राफ्ट रेडी होता. आणि ह्या असे 7चे 7 ड्राफ्ट तिथे टाकल्यानंतर त्यांनी सांगितलं की आम्ही हे करू, पण चर्चा अशी झाली की त्यांनी स्वतःहून विचारलं की तुमच्या ह्या स्वतःहून सांगितलं की आम्ही आणलेल्या जी घटना आहे, घटनेचे मसुदे आहेत, हे भारताला सांभाळण्यासाठी सफिशियंट नाही आहेत. सफिशियंट नाही याचा अर्थ त्यांनी आर्ग्युमेंट न करताच ते मसुदे आपले मागे घेतले, 7च्या 7 जणांनी. वेळ पडली असती तर गांधीजींकडे फुल बॅकअप होता, मेजॉरिटी सगळ्यात जास्त होती, त्यांनी तो इम्प्लिमेंट नाही केला, कोणीच केलं नाही. मग चर्चा झाली कोणाला आणायचं. मग कोण आपल्या विलियम जेनिंग नावाचे ब्रिटिश एक्सपर्ट लॉ म्हणजे कायदे पंडितच होते ते, आणि त्यांचा अभ्यास संविधानाचा फार झाला होता, कारण जगामध्ये ब्रिटिश राज्य हे जगामध्ये राज्य केलंय त्यांनी. त्यांच्या इथे जे नॉलेज होतं ते त्या विलियम जेनिंगला होते, म्हणून त्यांना इन्व्हाइट केलं की तुम्ही आमची संविधानाचा ड्राफ्ट बनवून आम्हाला हेल्प करावी. पण त्यांनी बाबासाहेब आंबेडकरांसारखा माणूस तुमच्याकडे आहे तर तुम्ही मला सांगण्यापेक्षा त्यांना सांगा असं सांगून मग त्याच्यानंतर प्रयत्न झाले. मग विजय पंडित, मोतीलाल नेहरू, सरदार वल्लभभाई पटेल या सगळ्यांनी बाबासाहेबांना मुंबईच्या सेक्शन मधनं त्यांना या ड्राफ्टिंग कमिटीवर आणायचं होतं, पण ते शक्य झालं नाही. मग बंगालमधनं आणलं गेलं. अशी रेस सुरू झाली. का बरं? तेव्हा 305 लोकांमध्ये अनेक बॅरिस्टर होते, एमिनंट बॅरिस्टर होते. काहीतरी एक त्यांची नावं मला आता म्हणजे अनेक सेक्शन मधले होते. मुस्लिम याच्यामधले म्हणजे त्यावेळेचे जम्मू काश्मीरचे पंतप्रधान म्हणून राहिलेले, आसाम मध्ये तेव्हा पंतप्रधान म्हणजे बिफोर 1947 जे होते त्यांचे राज्य, त्यांचे ते पंतप्रधान, चांगले चांगले कलेक्टर होते काही त्याच्यामध्ये, LLB झालेले लॉयर, एमिनंट लॉयर, ज्यांना बॅरिस्टर म्हटलं जातं. तुम्हाला माहित असेल सर, आपण सगळे लॉयर्स आहात, पूर्वी बॅरिस्टर ही पदवी कशाला द्यावी लागायची. तर त्यावेळेला आमचे वडील ऍडव्होकेट होते. बॅरिस्टर होताना म्हणे जो हायेस्ट मार्क्स मिळेल 65% वर त्यालाच बॅरिस्टर म्हणायचे, आणि 60च्या खाली असेल त्याला बॅरिस्टर म्हणत नव्हते. याच्यात एक अजून स्टुडंट अनेक आहेत, त्यांना सांगावं असं मला वाटेल की आपल्यालाही काहींना माहित असेल की पूर्वी लॉचे निकाल 2 ते 3% जसे IAS चे लागतात आता, तसे तेव्हा त्याच्या परीक्षा व्हायच्या आणि त्याचे निकाल तसे 2% 3% लागायचे. निकाल फार कमी लागायचे. आणि या दृष्टिकोनातनं त्यावेळची ज्युडिशरी ब्रिटिशांची कशी असावी याचा तुम्ही विचार करावा. आणि त्यांनी बाबासाहेब आंबेडकरांचं नाव सांगून संविधान बनवण्यासाठी 3 वर्षाला फक्त 13 दिवस कमी असेल, म्हणजे जवळजवळ 3 वर्ष त्यांनी दिल्लीच्या त्या बंगल्यामध्ये लिहून ती घटना पूर्ण तिचा ड्राफ्ट केला, आणि त्या प्रत्येक वाक्यावरती आर्ग्युमेंट केला. तिथे सगळे लॉयर, एमिनंट लॉयर असलेले, आणि कॅपिटल मार्केट मधले, कॅपिटल इंडस्ट्री मधले सुद्धा माणसं क्वालिफाईड होती तिथे. पण बाबासाहेबांच्या पुढे सगळे, म्हणजे त्यांच्या पुढे त्यांनी शस्त्र टाकले असं नाही, पण त्यांनी बाबासाहेबांच्या अनुभवाचा, जागतिक फॉरेन आणि इंडियन डिग्रीजचा हायेस्ट डिग्री त्यांनी ज्या घेतल्या त्याचा बेनिफिट आपल्या देशासाठी होईल या दृष्टिकोनातनं त्यांनी बाबासाहेबांना संविधान लिहिण्यासाठी परावृत्त केलं. आणि ते 3 वर्षात जवळजवळ करून आज आपण जे त्यांच्या नंतरच्या स्वराज्यामध्ये आपण राहतो आहे, तर त्याचा बेनिफिट आज आपण घेतोय. तर या अशा छोटे छोटे ड्राफ्ट्स आता हे आपण तुम्ही IPC सेक्शन बदलून आणलं तर याच्यावर किती ओहापोहा झालाय, आता सगळ्या देशात चाललाय. आपल्यासारखे एमिनंट माणसांचा ऍडवाइस याच्यात येतोय. अर्थात इम्प्लिमेंट करण्यानंतर आपला ऍडवाइस घेतोय. त्यांनी किती जणांचे ऍडवाइस घेतलेत, किती जणांचा गायडन्स घेतलाय, हे त्याच्यात त्रुटी असू शकतात असं मला वाटतं. तर तुम्ही सर्वांनी जी एक पॅनेल बनवावं ऑल इंडिया लेवलचं, आणि सजेशन्स गृहमंत्री, जस्टिस ऑफ इंडिया यांना देऊन काही तुम्हाला त्याच्यात बदल करावेसे वाटले तर ते जरूर होतील. आणि अशा एमिनंट माणसांकडनं आलेली सूचना वगैरे हे निश्चित भारत सरकार आपलं शासन हे ऍक्सेप्ट करतं. तर त्या दृष्टिकोनातही आपण तयारी करावी असं मी जरूर सांगेन. आणि आज मला या कार्यक्रमाला ऑनलाईन असलेल्या वर्कशॉपला आपल्या सोबत मला राहता आलं या दृष्टीने मला अतिशय आनंद होत आहे. माझे दोन शब्द मी जास्त न लांबवता इथेच माझे दोन शब्द थांबवतो आणि याही पुढे आपली प्रेझेंटी आपला गायडन्स आमच्या लॉच्या विद्यार्थ्यांना, लॉ फॅकल्टीला, सगळ्याच ज्युडिशरीच्या माध्यमातून ऑनलाईनमुळे हे शक्य होऊ शकतं. तर आपण निश्चितपणे आमच्या कॉलेजच्या पुढच्या कार्यक्रमासाठी जरूर याल असं मला वाटतं. आणि एवढे दोन शब्द मी सांगून आपली रजा घेतो. जय हिंद, जय भारत.
Thank you, Dada Saheb, for your insightful remarks on this workshop.
Okay, thank you.
Thank you, Dada. Now I request Naik sir to present vote of thanks.
Thank you, Akash sir. Am I audible?
Yes, sir. Loud and clear.
Okay. Thank you. Good evening. Good afternoon to all of you present here in this workshop for today. So we are at the conclusion of this program. So after listening to all these eminent personalities for today's program, Dr. Rahul Nikam sir, Dr. Anand Deshmukh sir from University Aurangabad, Chhatrapati Sambhajinagar, Professor Harshada Rajput ma'am, all these resource persons, they have given us in-depth, elaborative, and very comprehensive analysis is there from theirs of all these laws. Due to the time constraint, I
Hello.
Yes, sir. Yes, sir. It was
I guess there is some
glitch,
technical internet issue over there.
Okay. Yeah. You can continue, Akash sir.
Sir, I'll continue.
Yes. Thanks. You can continue. Yeah. I think he is not there in the meeting now. Yeah.
So first of all, I would like to thank all the resource persons who came here today, who joined us, who gave their valuable time to us, and have not only shared their time with us, but have shared their valuable knowledge, their experience with us. So thank you to all the resource persons, Dr. Nikam sir, Dr. Deshmukh sir, and ma'am, Harshada ma'am. So thank you. Secondly, I would like to thank the IQAC team, IQAC cell of Dr. Babasaheb Ambedkar Law College, because this is the need of the hour. Everyone knows that new laws have been implemented, but there is a lot of chaos and confusion, even in judges, in practicing advocates, in police officers especially. So this is the need of the hour. So thank you, IQAC cell, Dr. Babasaheb Ambedkar, and the entire team for organizing such a wonderful workshop, which has benefited not only to the participants, but also to me as an assistant professor. So I have learned a lot today. So thank you. Thirdly, our encouragement, Dada Saheb, he always encourages us to organize such programs. So thank you, Dada Saheb. Backbone of this program, Dr. Bhairam sir, principal sir, who has helped us not only technically, but otherwise also. Even if there are little problems, we always go to her and he always has a solution for any problem. So thank you. And this program would have been unsuccessful without the number of participants. So throughout the workshop, there were almost 99 participants, sir. Almost. There were 100 at one point of time. So participants have, I hope they have learned a lot. So thank you, participants, for joining and making this program a huge success. So thank you, everyone. I might have missed someone, so I thank all who will directly or indirectly involved with this program, with this workshop. So thank you, everyone.
Yes, sir. Thank you. Thank you. Thank you, Dr. Rahul sir, Dr. Babasaheb Mahendraji Nile. Yeah, and with the prior permission of Honorable Chairperson, Babasaheb Mahendraji Nile, now the meeting will be lived. We'll stop the meeting now.
Okay. Thank you.
Okay. I think Harshita madam is not there in the meeting.
Okay. So I'm receiving some messages from students, from participants, that the link is not working. So it is working properly. Just check it once again. Otherwise, I'll share another link on on WhatsApp group. So
On
do
our
not
WhatsApp.
for e-certificates. And students
Okay.
who will fill the e-certificates will who give their feedback will receive the e-certificates within 10 days on their email ID. Okay. I'll end this.
Okay, Naik sir now joined. Naik sir, it's over now.
Sorry, sir. Yeah, due to
No,
technical
it was,
issues, sir.
yeah, it was internet difficulty. We understand. Yes.
Thank you, sir. Thank you, sir.
Even